Supplementary old matter item number 1.
There is a appeal pending before the respondent number 1 member board of review. The management directed to dispose of that appeal.
All right, counsel, the appellant states that the only prayer. This is a writ appeal.
Yes, my lord.
Okay. He will be satisfied if a direction is issued to the member board of revenue to dispose of the appeal pending before him,
Yes, my lord. 140 of 2009.
being OSS case number 140 of 2009 at an early date. Paragraph. Consequently, a direction is issued to the member board of revenue to dispose of the above case within a period of 6 months from the date of receipt of a certified copy of this order. The appeal is disposed.
Supplementary list item number 2.
The copy
Kindly pass over, my lord. I am for respondent number 1. Kindly pass over, my lord.
All right. No, who's for the appellant?
I am for
The appeal is alive. I mean, is it
my lord.
you're pressing
Continuing.
for?
Supplementary list item number 3. Item 3, your lordship, sole appellant died. Within a week, I will file a
When
substitution.
did he die, sir?
Sole appellant
When did he die?
on 28/12/2021. Your
Why did he wait for 8 months?
lordship, one chance, 3 days time may be granted.
Chance and all, you'll have to file an application for condemnation of delay.
Yes,
There's
your lordship.
no, but what is the matter about and why do you want to?
Honorable single judge order is under challenge, your lordship. The section 41 of Consolidation Act, the final publication has been made, and the petitioner has filed a revision challenging the ROR, or lordship, for partition, your lordship. And while the proceeding is pending before the Consolidation Authority, the opposite party creating disturbance over the suit plot. Hence, he filed a suit for injunction before the Learned Trial Court. And in the Learned Trial Court dismissed the IA, and against that appeal is preferred. And in appeal, status quo order has been granted. And in the suit, when the revision is pending before the Learned Commissioner, the petitioner filed an application for stay of the suit till disposal of the revision. That order is petition is rejected. Ground that I have filed that petition under 151 of CPC, which is not maintainable, as because section 10 is the specific provision is there.
Correct.
On that ground, rejected. I assailed the order of the civil judge before the learned single judge. Honorable single judge hold that as because the property in Medio and the property which has been dispute is title is in dispute, so the suit is not to be entertainable, or injunction suit is maintainable, not to be stayed. That is the observation by the honorable single judge. That order is under challenge.
I've not understood the last part at all. What you're trying to say, anyway.
Injunction is there. Injunction.
Anyway, status quo has to be maintained by both parties.
Stay of the honorable single judge order is there, your lordship.
No. What's the point of that stay? Anyway, there'll be a status quo.
Stay regarding the suit.
Sir, either way, ultimately the prayer is for status quo to be maintained.
I am saying that the suit may be stayed till disposal of the revision. It is my contention, and I have supported by the judgment of this honorable court also, your lordship. 2 judgment, one full bench judgment that after 41 the revision is maintainable. Another judgment when the suit is for injunction simpliciter and the revision is for correction of ROR. The best way to stay the suit till disposal of the revision.
What is your stand, sir?
As per my instruction, I am for respondent number 1. Respondent number 1 also died. Then I have no information.
No. If you agree that the revision can go on till the suit is and the suit should be stayed, that will be another matter. Then you go and substitute yourselves in the revision petition.
Yes.
Your party is in the suit, your party is in the revision. Have you got yourself substituted there at least?
Yes, your lordship. In revision petition, yesterday that matter is before the director. We have substituted them as a party to the proceeding.
What about their parties? They are not substituted.
They are not substituted.
So you have to get yourself substituted in the revision petition. So why can't the revision petition proceed then?
It is there before
We'll
the
make
director.
it time bound so that you don't suffer too long.
Yes. Till that day, suit may be stayed, revision. That is my sole prayer before you.
What do you say, sir?
Sir, actually, I have no instruction.
Let's see the single justice order.
Lordship, at page, it is annexed to the retro page. That is internal page, Lord. Internal page 2. May I place it, your Lordship?
Yeah, please. I'm asking you to read, sir.
Yes, your Lordship. Inner page. The Land Council for the petitioner relies upon the reported case number Netranand Behera versus Ketravasi Behera 2010 2 wherein this court has held that a suit for perpetual injunction shall remain stayed as long as proceeding in pending before the consolidation of the ratio decided in that case is not applicable to the present case, as it is admitted case that the consolidation operation has already been completed in the year 2001. ROR has been issued in favor of the court. It is further admitted that a notification on 41 of the Act has already been issued. Therefore, a proceeding before the civil court is not barred. It is noted that Section 4 of the Act provides for effect of notification. Subsection 4 of Section 4 lays that every suit and proceeding declaration of any right of or interest in any land situated within the consolidation area in regard to which proceedings should be or ought to be started under the Act, which is pending before the NA civil court, whether for first instance or appeal, reference or revision, shall, on an order being passed in that behalf of by the court before which suit or proceeding is pending, stand abated. Thus, it is because of the provision Section 4 of subsection 4 of Section 4 of this Act suit abates. Expanding this provision, this court has interpreted in different cases that any suit in which the matter to be decided directly and substantially before the consolidation authority and the consolidation officer has jurisdiction to decide and grant relief in the claim of the suit shall remain stayed. But once a notification 41 of the Act issued, then the effect of Section 4 is wiped out, as Section 41 of the Act provides for closure of consolidation operation. In such situation, Section 4 of the Act shall not be attracted and the proceeding pending before the civil court need not be stayed. In this issue, your Lordship, I have a judgment of this honorable court, full bench judgment. I may permit it to place it. Guljar Khan versus consolidation officer. Section 41 remedy under Section 32 would be available. It cannot be spread out as to depend on probability of situation arising. Whether in particular case the same would be available, it has to be decided in consolidation commission depending on fact and circumstances of the case. How it is to be done? Para 37 and 38 I have to place, your Lordship. It is apparent that a forum has to be available to a person who has to be aggrieved after Section 41 notification has been issued, with any order having been passed or anything have been done during the consolidation operation affecting his right, title, interest as stated in the opening sentence of this judgment. There cannot be a right without any remedy, and according to us, remedy can be made available principally Section 37 of the Act. As to when such a situation may arise need not to be spelled out. Indeed, it cannot be the probability of such a situation arising cannot obviously be ruled out. The power being unfettered, we cannot put any fetter. Any such action of ours would render some really hard-pressed people without a remedy. May we repeat that we are not at the question as to when power of under Section 37 would be or should be exercised. As already pointed out, this power shall be available only and under compelling circumstances. But on compelling circumstances existing, we cannot sort out the invocation of the power. May we also observe that though section 37 has conferred an unfettered power, it is settled that every power, be administrative or judicial, has to be exercised in a reasonable manner, and the reasonable exercise of power inheres in its exercise with a reasonable time, as stated by this one. We therefore answer the reference by saying that despite closure of the consolidation operation, which would be result of the notification under section 14(1) of the Act, power under section 37 would be available, whether in a particular case the same would be exercised.
Can we also read it, sir? Just ask him to collect that. Gulzar. This is an appeal directed against the judgment dated 29th April 2013, passed by the learned single judge dismissing red petition civil 9534 of 2013, filed by the appellant, which in turn was directed against an order dated 10th April 2013 of the civil judge junior division Kujanga in civil suit number 78 of 2009, declining to stay further proceedings in the suit on account of pendency of consolidation proceeding before the consolidation officer under the Orissa Consolidation of Holdings and Prevention of Fragmentation of Land Act 1972, bracket Act, paragraph. At the outset, it must be noted that while directing notice to issue in the present appeal on 26th July 2013, this court had stayed further proceedings in the aforementioned civil suit. Stop. That interim order has continued since. Paragraph. Background facts are that the appellant and the respondents were recorded owners of properties in Sabik Khata number 240, plot number 1142, to an extent of AC 0.28 in Moza Balarampur, which stood recorded in the name of their ancestors. Full stop. In the remarks column, a note was made regarding possession. Full stop. Paragraph. During the initial stage of the consolidation operation, the land was divided into two plots and recorded separately in consolidation khata number 411, plot number 754, AC 0.14 in the name of the appellant and his other co-sharers, whereas Hal khata number 165, plot number 761, AC 0.14 was recorded in the name of the father of the respondents. Stop. Paragraph. It is stated that the appellant got the property in plot number 754 by mutual partition and therefore has no grievance as regards that area. Full stop. However, according to the appellant, while preparing the map, the consolidation authorities carved out Hull plot number 761 adjacent to the village road, whereas the plot of the appellant, that is 754, is towards the back side of the plot 761, adjacent to it. Full stop. This has prevented the appellant from approaching his land from the village road. Full stop. I At a time when the village had not yet been notified under Section 41 of the Act, the appellant filed consolidation revision number 2750 of 2005 before the Director Consolidation Orissa under Section 37(2) of the Act for correcting the map so that the appellant could approach his land from the village road. Paragraph. By an order dated 15 July 2006, the Director Consolidation accepted the claim of the appellant and directed the Consolidation Officer Kojanga to inquire into the matter and correct the map if necessary. So it is stated that the said revision petition referred by the appellant is still pending before the Consolidation Officer Kojanga for final adjudication. Paragraph. According to the appellants, the respondents in the meanwhile started raising a construction covering the entire frontage of plot 761 without any passage for the appellant to approach his plot from the village road. First up, this prompted the appellant to file civil suit number 78 of 2009, seeking permanent injunction against the respondents not to undertake any construction on plot number 761. Stop. After the civil judge dismissed the interim application for interim relief by the appellate on 11/12/2009, he approached the ADJ Jagat Singhpur in FAO number 53 of 2009. Full stop. By judgment dated 17 September 2012, the ADJ allowed the FAO and directed the respondents not to raise any construction or cause obstruction to the ingress and egress of the appellant to his land. Full stop. When the consolidation proceedings was pending before the CO, the appellant applied to the civil judge under Section 151 CPC for stay of further proceedings till final adjudication of the revision petition pending before the CO Kojanga. Full stop. By the impugned order, the learned civil judge rejected the prayer. Full stop. Paragraph. Agreed by the said order dated 10th April 2013, the appellant referred WP Civil 9534 of 2013 before the learned single judge. Full stop. By the impugned judgment dated 29th April 2013, the learned single judge dismissed the said petition, and accordingly the present appeal has been filed. Paragraph. Although the appellant cited the decision of this court in Nitrananda Behra versus Khetra Mohan Behra 2010 2 OLR 379 before the learned single judge in support of the plea that the suit had to be stayed till disposal of the consolidation revision, the learned single judge held that the said decision was not applicable since the final notification to Section 41 of the Act had already been published, and with that, the Consolidation Authority had no more power or jurisdiction to decide the claim of the parties, and the suit was itself not barred. Full stop. Consequently, it was held that the effect of Section 4 got wiped out and would not bar the civil court from entertaining the suit. Paragraph. Having heard learned counsel for the parties, the court is of the view that the impugned order of the learned single judge requires to be reversed for the following reasons. 1. A full bench of this court in Gulzar Khan versus Commissioner of Consolidation 1993 2 OLR 194 has authoritatively settled the legal position that only because of a notification to Section 41 of the Act, the power of the Commissioner to entertain a revision petition under Section 36 of the Act is not taken away. We'll stop it to explain that the revisional power was an integral part of the scheme of the Act. We'll stop. In particular, the majority judgment in Gulzar versus Commissioner bracket Supra bracket explain the legal position as under, take page whereas 35, 36, and 37. Paragraph. With the legal position being absolutely clear that the revision petition was not barred, the logical course would have been to stay the further proceedings in CS number 78 of 2009 while awaiting the decision in the consolidation revision case. (2750) of 2005, pending before the Director Consolidation Orissa under Section 37 bracket 2 of the Act. Paragraph. Consequently, while setting aside the impugned order of the learned single judge and allowing the present appeal, the court further directs that till the disposal of the aforementioned consolidation revision case number 2750 of 2005 by the Director Consolidation Orissa, further proceedings in CS number 78 of 2009 pending before the Court of the Civil Judge Junior Division, Kujanga, shall remain state. We'll stop. The Director Consolidation is requested to dispose of the revision petition within a period of 6 months from the the aforementioned consolidation case will now be listed before the Director Consolidation on 19 September 2022, and he is requested to dispose of the said revision case within a period of 4 months thereafter. Both parties will now appear before the paragraph. It may be noted here that during the pendency of the present writ appeal, the sole appellant has died. Full stop. His legal representatives, bracket LRs, have already been substituted in the aforementioned revision case, which will now proceed on that basis before the Director Consolidation. Paragraph. Counsel for respondent number 1 informs that he too has expired, and his LRs will have to be brought in record before in the aforementioned revision case, as well as a suit. I don't know. As well as in the suit. Full stop. It will be open to respondents, the LRs of respondent 1 to get themselves substituted in his place in the revision petition by filing an appropriate application, which will be taken up for hearing on the first day of listing of the present petition, of the revision petition, that is 19 September 2022. So the writ appeal is disposed of in the above terms.
Supplementary list item number 4.
Lordship, in item number 4, the opposite party number 6 is already serving in a government job. So I don't think there is any cause of action that.
Okay, no cause of action arises, survives for consideration. The writ appeal is accordingly disposed of.
Supplementary list item number 5.
My name may be.
Item number 5.
None appears disposed in opposition.
Supplementary list item number 6.
Item 6 will matter become influences no instruction matter.
All right. No instructions disposed of.
Supplementary list item number 7.
May I please do not. Lord, I am challenging the impugned order of the Honorable Single Judge. The Honorable Single Judge, my lord, what happened in this case, my lord, a civil court decree was passed against me in 1986, my lord, and for declaration of title and a recovery of possession. that decree was not put to execution for 12 years. And so therefore, it was the executability of the decree was barred by limitation. Thereafter, I remain in possession over the property for more than 40 years. Now I am also continuing in possession. On the basis of my possession, because I am the marfatdar, the properties belong to the DT, Lokanath Dev Puri. I am the marfatdar, I am the custodian of the property. So therefore, my father had no right to gift the property to the respondent, because it is the property of the DT without the permission of the Endowment Commissioner under Section 19. So it is a public DT. So therefore, the gift deed was illegal. However, he got a decree that thereafter the decree was not put to execution for 12 years. I filed the objection case before the consultation authority that my name should be recorded as marfatdar and the property be recorded in the name of the DT. But the consultation authority rejected my objection by saying that since there is a civil court decree, it is binding against the consultation authority.
Correct.
But what I am saying, Lord, the decree was not executed for 12 years, Lord. So
but how can the consolidation authority go behind it?
Lord, now
We
what
cannot go
happened?
behind it.
Now, what I am saying, Lord, now
Unless
what
it is set
happened?
aside by another court.
Lord, the
The
respondent.
mere fact that its executability has been, barred by limitation.
Your Lordship
means
is-
that
Your Lordship is correct, Lord. But in the meantime, what happened? The respondent number 1 has filed a suit for recovery of possession. That is CS number 3.
in that you file a cross claim, sir. You file a cross claim in that suit.
In that suit, what is my only limited prayer before your Lordship, Lord, that I may be permitted to raise all these questions, Lord, and this should not be operated as a res judicata.
Or it, you see,
So that is my only.
the learned single judge has decided the writ petition against the petitioner in the by the impugned order dated 16th April 2013 has dismissed, you say, the learned single judge has dismissed writ petition civil 24767 of 2011 filed by the present appellant by the impugned order dated 16th April 2013 on the ground that the consolidation officer could not have gone behind the decree of the civil court passed in the year 1986
Yes, ma'am.
against the
That is on 3-2
vis-a-vis the title and possession paragraph.
7-2-1986. ma'am.
7 through
7-2-1986.
decree dated 7/2/1986. Paragraph. Counsel for the appellant states that in the meanwhile, the respondents have preferred a civil suit
CS number 324 of 2005.
324 of 2005 in the court of the
In the court of the Civil Judge Senior Division, Puri. ma'am.
court of the civil judge senior division Puri, seeking possession of the property. Full stop. Counsel for the appellant therefore seeks leave to reserve the right of the appellant to raise all pleas in defense, including the pleas raised in the present appeal before the aforementioned civil suit pending before the civil judge senior division Puri, with the further request that the observations in the impugned judgment of the learned single judge should not come in the way of the civil judge senior division deciding the claim of the petitioner in accordance with law, appellant in accordance with law. Paragraph. In that view of the matter, the writ appeal is disposed of, reserving the right of the appellant to raise all the pleas available to him in the pending civil suit before the learned civil judge senior division Puri, and such pleas shall be decided by the aforementioned court in accordance with law, uninfluenced by any observations that have been made in the impugned order of the learned single judge.
Obliged.
Writ appeal is disposed of the above terms.
Supplementary list item number 8.
8 analogous writ appeals were dismissed allowed in the order.
In view of the dismissal of writ appeal number 265 2013 bracket regional PF Commissioner Mrs. Preman and the boy by this court by the order dated 26th August 2015, the present appeal is also dismissed. How many more such matters are there?
No, only another 5 matters are there, 4 have come, and another 2 matters are also still there.
Give us the number. We can
I'll
take.
give, yes. Serial number 10, 11 and 23. sir. Serial number 10, 11 and 23.
Oh, all three here.
Yes. Another one matter is left out. I will give my memo, madam.
All right. Same order in 10, 11 and 20.
Yes, ma'am. Then 11 and 23.
10, 11 and 23. Right.
Supplementary list item number 9.
Well, in this case, probably the order passed by the Honorable Single Judge has already been carried out. I don't have any instruction.
All right. Counsel, the appellant states that he has no instructions. It's post office.
Supplementary list item number 12.
19 has also become infructuous, ma'am.
19.
19, 19.
All right. All right. 19.
Item number 12.
None appears dismissed. No prosecution.
Supplementary list item number 13.
No instruction. No instructions disposed of.
Supplementary list item number 14.
Lord, item 14 and 15, the same question, only one question is there. Lord, the present appellant was the plaintiff. He has filed a suit for perpetual injunctions against the defendant who is the respondent before me, Lord. And issue has been framed. After the framing of issue, my Lord, the plaintiff has filed an application under Order 18 Rule 3 to reserving his right to adduce the evidence only issue number 3 and 4. Thereafter, my Lord, what happened on 39-192 has been filed, where the defendant has filed an application under 39 Rule 7. And it was allowed, though allowed, no step has been taken. Simultaneously, plaintiff has filed an application under Order 26 Rule 9. That has been allowed subject to the condition that, and one condition has been filed by the counsel for the plaintiff himself, that not to adduce any further evidence except the civil court commissioner. And thereafter, the civil court commissioner will be act as a court witness. Lord, the fact remains.
No, 1 minute. How did you then come to the single judge in a writ petition? I don't understand this.
Against that order, my Lord, I have filed an application under 151 to recall that order, because the council has no jurisdiction to give a consenting parties for and on behalf of the party.
Sir, 151 is not for review, please.
No.
The review petition is something else.
Yes, my Lord.
You can't invoke section 151 for review.
To recall that order, I have filed.
But this is all euphemism. You call what you should be filing as review, you simply call it recall and file 151.
Yes, that is to recall that order under section 151.
That is actually a review.
That is in fact as a review.
So it's not maintainable under 151 at all.
My Lord, the learned honorable single judge held that.
No, 1 minute. How did you come to the single judge at all? You're not first told us what did the civil court do under 151.
My Lord, in fact, there is no other provision to recall the order.
What are you saying, sir? Don't make us forget CPC.
Pardon?
So you're still in the civil court, correct? You filed a recall application in the civil court.
Yes, my Lord.
There is no provision for review in the CPC?
There is a provision for review.
So why are you saying there's no other provision other than 151?
No, my Lord. There is that review petition is there. Review provision is there. But instead of doing so, he has filed an application for 151.
All right.
And that 151 application has been rejected. Only one round, that the council has given the undertaking. It amounts to Order 3 Rule.
No, you only filed, sir. You're making same he has filed as if some other party. Your client has filed this, correct? Section 151, your client has filed.
Yes, my Lord.
How is it maintainable?
That is not maintainable. I am not saying that it is maintainable. But
you're agreeing it's not maintainable.
My Lord, now your Lordship has known the position. Intra-courts appeal is also not maintainable.
Nothing is maintainable. First of all, writ petition also not maintainable, sir.
May I pray one thing, my Lord? Both the writ application.
We have had a long argument to find out nothing is maintainable.
May I pray one thing, my Lord?
Yes.
My Lord, both the writ appeal can be disposed of to give a liberty to file the review application before the Lord.
Not now. After so many years.
Because the suit is pending, my Lord.
You boarded a wrong train. You want to go to the right destination.
Because both this suit is pending, my Lord. The suit is of the year is pending as on date also.
Right. Let it be pending, sir.
My humble submission that I may permitted to raise the questions before the learned trial courts.
Nothing, sir. Whatever you have in law, you'll do. We don't permit you as such because we don't want another litigation to start now. You say neither was the application under section 151 CPC for a disguised review maintainable, nor a writ petition against such an order refusing to entertain such an application. Full stop. Much less is the present writ appeal maintainable against such an order of the learned single judge. Consequently, the court has no hesitation in dismissing both these appeals. And it is so ordered. All right.
Lord, 14 and 15 same.
All right. 14.
Supplementary list item 16.
16, my lord, on behalf of Mr. Das, my lord, can we pass over, my lord?
All right.
I am for opposite partner 4, my lord, in that item 16, my lord. I play a weak time because my lord, the person who filed the writ appeal is not the secretary of the governing body. In between, the governing body has been.
Let us see what he comes and says. Pass over.
Supplementary list item 17. Item number 17.
None appears dismissed, no possible.
Supplementary list item number 18.
None appears dismissed, no possible.
Supplementary list item number 20.
None appears dismissed, no possible.
Item 16, my lord.
Yes.
Can it be taken now? I'm ready.
Yes.
I'm ready. May I please? My lord, in this case, the order removed is at annexure 2. That is page 22. The order of the Honorable Single Judge
Yes.
holding an institution having both +2 and +2 wing to be a composite college, though the law is otherwise. The law laid down right since 1985 by our own High Court in the division bench, and subsequent judgments, which have also been, some of them has also been confirmed in the Honorable Supreme Court. The law has been settled that there is no concept of composite college after the amendment of the Odisha Education Act in the year 1989. All these judgments, the first judgment, I have given the bunch of judgments, madam. The first judgment is of its kind is, though it is an unreported judgment, but that is the first case, OJC 1486 of 1994.
No, but who's this opposite party? Respondent number 4.
Respondent number 4 is the principal of that institution. He claimed there that this notification, wherein the government has notified the degree wing of the institution. Initially, it was one institution. By operation of law, it has to be segregated.
And who are you? You're the secretary of the governing body.
Governing body of the degree college. We say our case was because they have challenged this notification annexure 1, page 20. Kindly see page 20, my lord. This was impugned before the Honorable Single Judge.
Yes.
Government notification.
Yes.
The serial number 1 of that.
Yes.
Baleshwar, Santilata Degree Mahavidyalaya. This is how the order says, in pursuance to the power conferred by clause B of section 3 of the Odisha Education Act 1969, read with para 1 of para 3 of the non-government colleges, junior colleges and higher secondary school granted in 2004. The state government do hereby notify the following 13 private education institutions as aided education institution to receive block grant in terms of the provision of para 3 of the grant.
So why is he unhappy with this?
They say it is a composite college because the +2 wing of the same college was under the previous grantinate, regular grantinate principle as prevailing at the relevant time since 1988. The institution name was Santilata Mahavidyalaya. There, this act has not come. Bifurcation concept was not there. Degree wing was opened in the year 1987. The act was amended in 1989. Thereafter, the government says, even in an existing institution where both +2 and +3 are there, that is to be segregated as 2 units. After the concept of 10 +2 +3 scheme was introduced by the central government, followed by the state government. So it was segregated. The first of its kind, the government has created all this confusion, my lord, with all respect. They allow some institution to continue as composite status, but other institutions are segregated as +2 and +3 wing. They want to take the advantage, saying that no, it is one institution, so that they will get the benefit of grantinate of the old scheme. But after the introduction of this block grant scheme in the year 2004, everything is to be done as per the new gratinate policy and receive 40%, 60%, all this procedure manner. So they says if this name is degree college, now you have segregated our institution, which is not permissible. And the Honorable Single Judge, despite this judgment was cited to the Honorable Court by the state as well as me, my lord. But he says no, because the government in a circular listed about 300 institutions having composite status. This institution is a composite college. His name should be Santilata Mahavidyalaya. This notification was interfered with. And page 20, instead of Santilata Degree Mahavidyalaya, it should be treated as Santilata Mahavidyalaya. That was their objection. My response submission is, once the law is settled that there is no concept of composite college, even if it was functioning as a composite started, it has to be segregated.
No, but there was no stay of the single judge's order by the division bench.
This order.
This
No,
not
what
stay.
happened, my lord, there is a development. Another single bench of this Honorable Court, all the judgment I have given, held this judgment, that impugned judgment, my lord, to be per inquirium.
Oh,
That is there, my lord, I have given.
okay.
That has also been upheld by the division bench of this Honorable Court. That judgment, my lord Justice Ekerath, Dr. Ekerath, WPC 22530, sorry, I could not number it, my lord. It what's middle? I may be permitted to get that copy for my lord. WPC 22530 2012. I may read, my lord. In paragraph 12, the concluding, after discussing about this per inquirium and all these things, paragraph 12, the Honorable Court has held, in view of the authoritative pronouncement of the apex court in the case of Synthetics and Chemicals Limited Supra, this court holds the judgment in the case of governing body of D.R. Noyapalli College Plus 2 Supra and Jatindranath Das Supra, this case, present case, are per inquirium.
And that's been upheld by the division bench.
This has been upheld in the division bench in writ appeal number 225 of 16. This judgment.
Oh,
So now, my lord, that judgment is
gone.
virtually gone. But because unless, my lord, we have filed it earlier, because the first judgment is 1486 of 94. By my lord Justice D.P. Mahapatra, as my lord Didan was, and Justice B.N. Das on 7/8/1995. This old judgment. That was holding the field, and that was also confronted to the Honorable Single Judge. So this is the law in the field. That was not taken care of, and the order is passed. Unless, my lord, expressly set aside this order, there is confusion, my lord.
So as of today, it's running as one consolidated college, one consolidated Mahavidyalaya.
Virtually, in practical, my friend will better say, they are, because I am conducting many cases for this institution also. My experience is they're treating it separate. Government is till that, despite this judgment, after the judgment in that SS Mahavidyalaya, wherein it has been declared non this per inquirium, they're treating this as a separate institution.
I see.
They have also, I have filed a document, even past also, they have constituted two governing body for this same institution, one for degree college, one for plus two college.
All right.
That is there on record. I have filed it. So only because of the authoritative decisions of this Honorable Court, my lord, I don't want to take much time off, my lord.
My only preliminary objection, my lord, if my lord see the cause title, this writ appeal was filed by one Santilata Jana, saying that she is the secretary of the governing body, my lord. And this writ appeal was filed in 2013. And I have given the document on 5th of July 2013. After the institution became an aided institution, the governing body has been reconstituted. My lord, I've given the annexure A/4 and annexure B/4. My lord, kindly see. Neither the Santilata Jana was the secretary nor a member of that governing body. So on her behest, this appeal is not maintainable. This is my first submission, my lord. Because, my lord, if he is not the secretary of the governing body, now she cannot file, my lord, this appeal. My lord, kindly see the governing body which was constituted in 2013, 5th of July. Writ appeal was filed in September 2013. My lord, kindly see A/4, page 7, my lord.
Yes.
My counter, my I just filed an affidavit, not counter, my lord, I filed an affidavit.
Yes.
Indicating that the governing body was constituted. This is an aided educational institution. As per rules, the principal is the ex officio secretary of an aided institution. A private person cannot continue as a secretary of the aided institution, and governing body was constituted on 5th of July 13, taking Jatindranath Das as principal cum secretary ex officio member, my lord. No, here Santilata Jana is the secretary on 5th of July, my lord. So on the behalf of Santilata Jana, my submission is this appeal is not maintainable.
Yes.
So once she cannot file this, so she is not the secretary of the governing body, so she cannot challenge my own submission. This is cause title. She filed this appeal as a secretary of the governing.
Anyway, so what's the next point?
This is my own submission, my lord. The appeal is not maintainable.
That's all. No other submission.
No, my lord.
So for this objection, I have, that is also not well taken by my friend. If my lord will see the impugn order, which is challenged, page 26, my condition, para 5. I have filed as Santilata Jana, not as the governing body, not as the secretary. And that my intervention in that writ petition was allowed. I filed a review petition that was also rejected. And thereafter, I am filing the writ petition. Santilata Jana by the individual. Because I am the founder, I was the secretary of the institution. So on this, it has been clearly stated, one Santilata Jana filed an application number, miscase number so and so.
Where are you reading?
My lord, page 26, para 5
Right.
of the impugned judgment.
Right.
One Santilata Jana filed an application number, miscase number so and so with a prayer to implead her as opposite partner number 4, stating in that she has filed a case bearing granted case number 30/2003-30 before the state education tribunal against the inaction of the state functionaries for not verifying
So
the
in her
records.
individual capacity, she's done it.
Yes,
All right.
I was, and my intervention was allowed. I was allowed to participate. So who else can challenge this?
All right. This
And-
writ appeal is directed against an order dated 1810-2012, passed by the learned single judge. Disposing of writ petition civil 3378 of 2010 filed by the respondent, wherein a notification dated 1st July 2009 issued by the Commissioner cum Secretary to the Government Higher Education Department, treating the appellant college as single quotes Shantilata Degree Mahavidyalaya, Putikiri, under Section 3 of the Orissa Education Act, bracket OE Act, bracket. Was upheld. And it was held that and a direction was issued to the Secretary, Higher Education Department, to correct the said notification in respect of the institution as single quotes Shantilata Mahavidyalaya, Utkiri, in place of Shantilata Degree Mahavidyalaya, Utkiri, and to release block grant to the staff whose services had been approved by the state opposite parties. Paragraph. This court has heard the submissions of learned counsel for the parties. Paragraph. A preliminary objection is raised by counsel appearing for the respondent. Number 4. That the present writ appeal filed by Srimati Shantilata Jaina as single quote secretary of the governing body of Shantilata Degree Mahavidyalaya, unquote, is not maintainable, since at the relevant time she was in fact not the secretary of the said governing body. Paragraph. In response to this submission, it is pointed out by Mr. Das that the learned single judge took note of the fact that the present appellant had sought to intervene in the pending writ petition by filing a miscase number 7369 of 2010. In the pending writ petition. Full stop. Para 5 of the impugned order of the learned single judge notes this fact as under. Take para 5, page 26. Paragraph. In that view of the matter, the preliminary objection of the respondent is hereby to the maintainability of the present writ appeal is hereby rejected. Paragraph. Interestingly, the impugned order of the learned single judge has been held to be per inferium by the order dated 6th March 2017. No, the order dated 8th April 2016. But the judgment date is 8th April 2016 of another learned single judge. In writ petition civil 22530 of 2012, bracket, governing body of Abhimanyu Samanta Singar College, Balia, versus State of Orissa, bracket. The said order of the learned single judge was approved by this court by the division bench, approved by the division bench of this court by the order dated 6th March 2017, writ appeal 225 of 2016, bracket, governing body of Abhimanyu Samanta Singar College versus State of Orissa and others, bracket. Consequently, as far as the impugned judgment here is concerned, with it already having been declared per incurium and such declaration being affirmed by the division bench as pointed out here and before, this court has no hesitation in setting aside the impugned order of the learned single judge. The appeal is allowed in the above.
There is a review petition I have filed that was also dismissed. Can I? It is a consequence, but can I? May Premala Annexure 3 also be set aside? That is the review order. That by the same.
Consequently, the order in review passed by the learned single judge
3813
is also hereby set aside.
Obliged.
Supplementary list item number 20.
None appears this was no.
Supplementary list item 21.
May I please, your lordships?
Yes.
Here, my lord, the appellant challenge the impugned order under Annexure 6 passed by the Honorable Single Judge, my lord, dismissing the writ petition and confirming the orders under Annexure 4 and 5 passed by the opposite party number 3 and 2 respectively, my lord. The petitioner was initially appointed as Anganwadi worker, my lord. Your lordships may kindly turn to Annexure, my lord, 3. That is the appointment order. Annexure 2 is the selection list, my lord. Selection list dated 31st December 2009, my lord. She was given 5 marks extra for her qualification, that is COVID in Hindi, my lord. I have annexed the COVID certificate, my lord. Your lordships may kindly turn to page, my lord, 9 and 10. Page 9, my lord.
There is no stay, there's no interim order passed in the present writ appeal. In the present writ appeal, there is no interim order, correct?
No interim order.
So she has continued then.
She was disengaged after the appeal was filed by the respondent number 5, my lord.
No, that is your client. The appellant has disengaged.
Appellant's appointment was set aside.
Correct.
In pursuance to appeal filed by the respondent number 5.
Correct.
Against that, my lord, the appellant preferred the appeal before the respondent number 3, my lord. The respondent number 3 dismissed the appeal on the ground that, my lord, the qualification COVID is not a higher qualification, whereas the qualification COVID is admittedly the higher qualification, my lord. The certificate says so. Your lordships may kindly.
No, 1 minute. So against that, you came in a writ petition.
I came in the
judge that was dismissed.
My lord.
You now come in a writ appeal.
Yes, my lord.
So this is for the post of what?
Anganwadi worker, my lord.
So how old is she now?
Now she is, my lord.
43.
Yes, ma'am.
43.
All right.
My lord.
All right. Yes. Who's appearing for opposite party? Respondent number 5. Was respondent number 5 noticed or stayed? mean, no notice was served.
10/12/2013, my
No, notice is issued only to respond number 4, not to 5.
my
Just see this 10/12/2013.
my
Notice is issued only to respond number 4.
respondent number 5 is the affected party. Your lordship may issue notice to the
Now
respondent.
at this stage,
Because my lord, there is a genuine grievance of the appellant, my lord, here, my lord.
no, but how come you did not, you were very much there when the court confined the notice only to opposite party respond number 4? You should have asked for notice to be issued for respond number 5. She is currently working there.
My lord, she is working there.
So without hearing her, you can't possibly succeed.
Because-
Just one submission. The impugned order, my lords, at para 3, my lords, in her application, she has not mentioned that her qualification has this codiv, which, my lords,
Where is this impugned order?
my lords, it's at page 28, my lords. Para 3, my lords. My lords, have you?
Where is it? Page 29 is missing.
Page 28, my lords.
Let's see the paperwork.
The courts below have given concurrent findings of the fact that the petitioner has not
29 is
mentioned
missing.
in her application form that
29
she
is
has passed OBIDA, which is stated to be higher qualification for awarding 5% of extra mark for her to her. The second question is whether the OBIDA itself is a higher qualification or not, which entitles the petitioner to 5% of additional marks on the ground of higher education, higher qualification. My lords had called for the records. I have the records. I can, my lord, show the records where, my lords,
It's not
the
mentioned.
application form, my lords, it's in Odia, and that's where. This is asking, see serial number 7, where she says her qualification is metric pass, which is 10th. Serial number 7, my lords.
You only mentioned matriculation.
She mentioned matriculation.
Not
She did not
OBIDA.
mention the higher qualifications. And that that certificate has been given, has been submitted after, my lords, the last date of this election. So therefore, my lords,
At the time of scrutiny.
No, but you have to mention your application form.
My lord, admittedly, I have not mentioned my. But I was appointed by the selection committee. Your lordships may kindly turn to page 11, my lord. I was initially given 5 extra mark.
But you did not produce any certificates, sir.
On the last date of scrutiny selection, I had produced my.
No, but that's the whole thing. No? There's enough case law to say that you can't produce subsequently. Because the requirement, it has to be submitted with the application. The challenge in the present writ appeal is to an order dated 13 September 2013 passed by the London single judge dismissing writ petition civil 17699 of 2013 filed by the present appellant. Full stop. Paragraph. Against the appointment of the petitioner's Anganwadi worker in the Center 2 of Gantiapalli under Bijepur block in District Badgar. Respondent number 5 filed an AWW appeal case 42 of 2010 before the Additional District Magistrate (ADM). It is pointed out by respondent number 5 that the present appellant, who had been awarded 5% additional marks for having passed COBIDA (Hindi) by the selection committee, had in fact not disclosed in her application form that she had the higher qualification, and had also not enclosed the certificate along with her application form. This was accepted by the ADM, who allowed the said appeal. Full stop. The present appellant then challenged the said order before the collector bracket in AWW bracket A bracket case number 8 of 2012, which came to be dismissed by the order dated 20 July 2013. Full stop. Agreed with the said order, the appellant filed writ petition civil 17699 of 2013, which has been dismissed by the learned single judge by the impugned order. Full stop. While dismissing the present writ petition, the learned single judge has observed as under reproduce paras 3 and 4. Paragraph. Consequently, the appellant does not dispute that the appellant had failed to mention in the application form that she possessed the higher qualification of Kobida bracket Hindi. Also, he also does not dispute that the certificate of such higher qualification was not enclosed with the application form. Full stop. He, however, states that it was produced at the time of scrutiny of the documents. Paragraph. The requirement was that the appellant should have mentioned in the application form in the relevant column that she possessed the higher qualification. Full stop. And we have this court has produced the original application form as produced by counsel for the learned additional government standing counsel for the government, and find that indeed the appellant has not mentioned in the application form that she possessed the higher qualification of Kobida bracket Hindi. Full stop. Admittedly, full stop. The record also shows that she did not enclose the certificate of such higher qualification with the application form. Full stop. In the circumstances, selection committee ought not to have permitted the appellant to produce such certificate at the time of scrutiny of the documents, which was impermissible as per the time schedule set down by the authorities themselves. Full stop. No such preferential treatment could have been accorded to the appellant. Full stop. Consequently, the ADM was justified in setting aside the appointment of the present appellant as Anganwadi worker. Full stop. The court is unable to find any error having been committed either by the collector, Bargat, or by the learned single judge in affirming the aforementioned order of the ADM. The appeal is accordingly dismissed, no costs.
Item number 22.
None appeals dismissed, no costs.
Supplementary list item number 24.
My lord, in this case, the order of the Honorable Single Judge, that is Annexure 5, is under challenge. My lord, the brief background of the case is that the opposite party number 1 is having the cold storage. And for that, it was classified within the categories of agro-industrial consumer. And this is the agreement, is supposed to sign the agreement being a consumer. And this agreement is, your lordship will find page 13, that is on 16/5/2008. Page 13, Annexure 1. And your lordship will find that it is the duration of the period is 5 years. That is page 14. And the duration of agreement will commence from the date of its execution and shall continue to be in force until expiry of 5 years from the date of supply, and thereafter shall continue until the same is determined by either party giving to the other side transfer. And this category of industries is classified because accordingly, in what category, who is the consumer, the tariff is accordingly fixed, annual revenue requirement, while it is OERC prescribed that. And this is the category, my lord, page 16, It was agro-industrial consumer. Page 16. But then the OERC amended this. Amended this. And before that, Lordship will find page 20. This agreement and the classification is also subject to change as per the clause that is in page 20.
Who's for the other side, sir? You're arguing at length. Who's for the other side? The affected party is respondent number 1, correct?
Yes.
Have they been served?
Notice was issued on 21/11/14.
No, there's no interim order, correct?
No, interim is not there, but it is having a financial impact. Supposing your Lordship decide, then for that period we can charge it under that category. That is only because the consumption of electricity, it is having the ramification also over the other public, because that is a revenue requirement of the distribution license.
It turns on its own facts.
And here your Lordship will find what happens, that it is subject to whatever the classification time to time is changed. The agreement accordingly will be modified.
Let's see the single judge's order.
My Lord, single judge's order is Annexure 5, page 38. Page 38, it comments from 40. Page 40. My Lord, what we had given the notice that you come within the general purpose category, because your agro-industrial consumer classification has undergone the change by the OERC, and that is as per the notification, that is annexure. Your Lordship will find that page 23. Well, these are classified and agro-industrial consumer no more there. And these activities which has been substituted, page 23, OERC has amended the regulations, regulation 80. Because under the 80, there are different classification. And here your Lordship will find the Honorable Single Judge, also the GRF. And they held that it is coming within 85 Roman 3, allied agro-industrial activities. But according to us, it does not come within that. Rather, it comes within 82. That is general purpose.
They're dealing only with vegetable activities, sir.
My Lord, what is the distinction is that it is who is not doing any commercial activities, only for the freezing purpose, only that is applicable to them. But here, it is having the commercial activities, when the selling of the product, everything, and after freezing, then that is why they are coming within a different tariff, and it comes within regulation 80 within bracket 2, that is general purpose tariff. So that is why we are given the notice after these notifications, that is cause of action arises from here, annexure 3, page 25. We requested him that you please come forward. So you are requested to execute fresh agreement for GP tariff with retrospective from 1/4/2009. It comes within GP tariff, not allied agro-industrial cover.
So vegetables is allied agro only, sir.
Well, allied agro
growing only vegetables.
My Lord, that is on 85.3, my Lord. It clearly indicate in the tariff notification, which is amended 85, my Lord.
Right.
85.3. May I read, my Lord, for convenience?
That I was drawing my Lordship's attention. That 85.3 that we are saying, we are disputing that.
There is no such
it's already quoted in the impugned order.
Yes, in the impugned order that has been quoted, and the GRF order was confirmed by the Honorable Single Judge, holding that on bare reading only, that arrived at the conclusion, page 43.
We don't agree with you, sir. The challenge in the present appeal by the executive engineer, bracket electrical, Baripada Electrical Division, NESCO, is to an order dated.
Now it has been TPNODL.
Bracket, now TPNODL, bracket, is to an order dated 28 June 2013, passed by Learned Single Judge, dismissing the appellant's writ petition Civil 27046 of 2011, which in turn challenged an order dated 8 August 2011 passed by the Grievance Redressal Forum (GRF) Baleshwar in GRF CC number 212 of 2011. Paragraph. Full stop. The learned single judge rejected the prayer of the appellants for a direction to the Mayur Bunch Cold Storage Private Limited, open quotation, to accept the categorization of his unit, unquote, as an agro-industrial consumer.
Allied agro-industrial 85 Roman 3.
3 minor. Allied agro-industrial.
You wanted to treat him as what?
We want to treat it as GP category, GP purpose.
No.
That is 82 under the regulation.
Right. To categorize his unit as GP consumer, and for bills to be raised accordingly. Paragraph. The admitted position is that the respondent number 1 is a cold storage unit which only preserves vegetables. Full stop. By the Fourth Amendment to the OERC distribution condition of supply code 2007, a new category of single quotes agro-industrial consumer, unquote, was inserted from 16th May 2008. Accordingly, an agreement was entered between the appellant and respondent number 1 on that basis.
Further agreement has not been executed.
Full stop.
Well, after amendment, no further agreement is there. In the manual also, there has been various other amendments.
Full stop. The attempt by the present appellant, by letter dated 12th August 2009, requiring respondent number 1 to execute a fresh agreement by being categorized as single quotes GP consumer, unquote, paying a higher tariff rate, was challenged by the respondent number 1 before the GRF Baleshwar in the aforementioned case. That prayer is allowed, and a direction was issued to the present appellants to charge respondent number 1 under the single quotes allied agro-industrial activities, unquote, with effect from 26th October 2009. Full stop. The above order was based on the several similar orders of the Ombudsman, directing the change in the tariff category of cold storages from single quotes GPC to allied agro-industrial category, unquote. Referring to clause 80 bracket 5 bracket 3 of the OERC code, Fifth Amendment, the learned single judge has noted that the amended regulation was not meant to confine the cold storages only to fish, meat, etc., but also to flowers, vegetables, etc. Paragraph. Having heard learned counsel for the appellant, this court is not able to be persuaded that respondent number 1 ought to be categorized as a GP consumer, when clearly its activities fall within the description of, open quotation, allied agro-industrial activities. Full stop. The fact remains that the cold storage operated by respondent number 1 is used only for storing vegetables, and that is within the purview of single quotes allied agro-industrial activity, unquote. Consequently, the court is not persuaded that any error has been committed by the learned single judge in dismissing the appellant's writ petition. The writ appeal is accordingly dismissed.
Obligation.
Supplementary list item 25.
No, sir, I am appearing for the opposite party.
All right, none appears for the petitioner. Dismissal not possible.
Supplementary list item 26.
May I please, sir? Already in the meantime, the government has implemented most of the suggestions given by Honorable Justice P.K. Mahathi Commission, my lord. But
So
we have
nothing
given
survives
some,
then.
my lord,
Nothing survives then.
my lord, we have given some suggestions, my lord. Well, this year, my lord, there is a huge waterlogging in and around the temple, my lord. We had given a suggestion that the river, namely Musanai, should be dredged and maintained so that the rainwater could be discharged, my lord. And also to sensitize the servitors and the priests. They are always misbehaving with the visitors, my lord.
So that we can't generally give a direction like that.
Only
Please.
to
We can't agree with you that they're always misbehaving and all that. So that will cause more problems.
There is lot of development.
Yes, my lord. I agree.
So,
yes, my lord.
You say the counsel for the appellant petitioner fairly states that most of the recommendations of the Justice P.K. Mahathi committee have been implemented. Full stop. Further, during the pendency of the present petition, a lot of development activities have taken place in and around the temple.
Sri Jagannath Temple.
Sri Jagannath Temple at Puri. Full stop. In that view of the matter, the court would not like to issue any further directions in the writ petition, and it is disposed of as such.
Supplementary list item 27.
I appear for the intervener petition.
Item 27.
None appears. Dismissed in office.
No instruction.
No instructions. All right.
Item 28.
And your lordship, public interest litigation, my lord. Land belong to the government, my lord, and in the ROR, it is recorded in the name of Cuttack Municipal Corporation, my lord. And opposite party number 6 and 7, they are encroached a portion of the land for business purposes, that bricks and chips and sand. They are stacking over there and for selling purposes, my lord. And annexure, your lordship can have a glance to annexure 3 and 4. That is the Amin report and RI report, my lord, at page 19 and 21. That clearly shows that they have doing this business and encroaching the government. And my limited prayer, my lord, CMC should take proper steps to.
Respondents 4 to 7 have been served. No reply has been filed with the government.
that's not filed. It is CMC is seeking some directions against CMC.
But in fact, wherever the encroachment is there, the joint squad always the collector, CMC and CDA all together do that. Your lordship directive, the unauthorized encroachment is there.
That is an enforcement team.
Yes, sir.
And there is a dedicated team for eviction of unauthorized enclosures.
All right. You see, the prayer in the present petition is for a direction to the Cuttack Municipal Corporation, bracket CMC,
Also
to cause an
collector.
inquiry and take steps to
The
remove
prayer is to both the parties.
unauthorized
CMC is
and
also
illegal
also-
encroachments on the land, on the CMC's land in Khata number 118, plot number 255, area 0.029 decimal in Moza Cuttack, unit 36 Raja Bagicha of Cuttack town. You say by an order dated 2nd January 2017, this court allowed an application filed by the petitioner and implemented opposite parties 6 and 7 to the writ petition. Full stop. Subsequently, on 7th September 2017, notice was directed to be issued to opposite parties 4 to 7. Full stop. Although the opposite parties 4 to 7 have been served and have been represented by counsel, today none appears on their behalf. Full stop. There's also no counter affidavit by any of those respondents or even by the state. Full stop. In the circumstances, direction is issued to the CMC to inquire into the matter and follow the due process of law if it is found that there is any encroachment in the aforementioned plot number 255 in Khata number 118 in Moza Katak, Sheher, Unit 36, Javakicha. Under intimation to the present petitioner. These steps be taken within 4 weeks from today. The steps be initiated within 4 weeks from today. Also, it is reiterated that the CMC will proceed only after following the due process of law. The writ petition is disposed of the above terms.
Supplementary list item 29.
None appears to assistant ombudsman.
Supplementary list item 30.
My lord, the matter has become infectious.
All right.
Yes. Supplementary list item 31.
Madam, item 31, I was the conducting counsel, my lord. In the meanwhile, I have been engaged as central government counsel, so I could not conduct this case. Let 2 weeks time be given. The petitioner should be engaged some other counsel.
Not so late, sir. When were you engaged as state counsel?
20 September, in the month of September, 21.
21?
Yes.
So you have waited for almost a year now. What is the matter about?
May I be permitted?
My lord, there is my writ petition, my lord, WPC number 1.
Change the name of Tarabalo Hot Spring to Nilakandar Hot Spring.
Yes.
Yes.
What is all this? Why should we entertain a PL for all these things?
My lord, the matter is that, my lord.
You are for the petitioner now?
Yes, I am petitioner WPC number 19235 of 2016, my lord. The hot spring, my lord, in bearing Khata number 987, plot number 226, and its Hal Khata number 94328, plot number 219, 220, 221, 222, 227, 228, Mauja Nilakantha Prasad. Hot spring are there, my lord. In this Khata number, ROR, the record recorded in the name of village Nilakantha Prasad, and in the year 1994, my lord, the tourism department identified this as hot spring, my lord. After identified, my lord, wrongly naming this as hot spring, Toravalo hot spring. The land situated village Nilakantha Prasad, but the hot spring name in another village, that is Toravalo. Therefore, my lord, in the year 2019, your lordship may kindly see Annexure 7, page 42. The tourism department directed to Collector Nayagarh to inquire into the matter, actually where the hot spring situated. Accordingly, the Collector Revenue Department, Nayagarh, inquiry into the matter properly, and it is found that the said hot spring area, plot number, Khata number, in the name of village Nilakantha Prasad. Therefore,
the collector Nayakar Malor requested to OP number 2, Director Tourism Department Odisha, renaming Torobalo H. Nilakantha Prasad Hot Sulphur Spring, inviting a reference to the letter on the subject cited above. I am to say that on inquiry, it is revealed that the hot sulphur spring located on the land in 4 different holding, which is situated below, and the set khata number and plot number in the village Nilakantha Prasad. So the prayer of the petitioner is that though the land situated in the village Nilakantha Prasad, the hot spring name may be naming as Nilakantha Prasad Hot Spring. Therefore, I pray before this honorable court, as for Annexure 7, page 42, pending before the tourism department, director of tourism, that may be disposed.
We are not agreeing, sir. We don't want to interfere in these kind of issues in a PIL.
May I permit it to? What happened actually, my lord? I have submitted one date chart, my lord, earlier. That is there in the record, my lord. At point 10, 5/2/2016, my lord, this honorable court, the honorable single judge, disposed of the writ petition by OJC number 13194 of 2000, directing the opposite party that the name of the said hot spring may be described as per the historical name of the government, my lord. Thereafter, 2 writ appeals have been filed by these petitioners and also my learned friend's client, my lord. And in that writ appeal, my lord, the order was set aside as because this was in the nature of PIL, but the honorable single judge has given a direction that the hot spring may be named in historical name. Thereafter, the 2 writ appeals have been disposed of with a common order directing that the writ petition be listed before the assigned bench. Thereafter, my lord, the petitioner filed one miscase in that writ petition, amending the writ, my lord. Thereafter, my lord, what happened? That order, in that order, the opposite party number 5 on 13/1/2017, my lord, that order was set aside. The honorable single judge's order was set aside. Thereafter, my lord, the opposite party issued a notification basing upon the order of the honorable single judge that the name may be as Nilakandar, my lord. Thereafter, my lord, that notification was itself ab initio void as because that order of the honorable single judge was set aside, my lord. Basing upon that order, the notification was issued, my lord. Thereafter, my lord, on 25/2, the opposite party number 3, I have annexed that order, my lord. Kindly have a glance to page 167. 169, my lord. There is there. Page 169, notification. The Honorable High Court of Orissa, may I place, my lord? The Honorable High Court of Orissa, Cuttack, has passed verdict in connection with the writ petition of OJC number 13194 of 2000, filed by Sri Hariharan Nayak and others of village Nilakantha Prasad in the district of Nayagarh to rename the Taravalo hot spring as per the same historical name. But this notification was based on the order passed by the honorable single judge, and that order of the honorable single judge has been set aside in the writ appeal, my lord. Therefore, this notification is, my lord, bad in the eye of law, my lord.
You don't agree, sir?
What is the claim of the petitioner, my lord? The present petitioner in this petition have donated the land for development of that Taravalo hot spring, and the Union of India in Tourism Department, my lord, kindly have a glance to the submitted a detailed survey report by the Geological Survey of India, my lord, at page, my lord, at Annexure 5, page 59, wherein the name of the hot spring has been described as Taravalo, and detailed survey report taking into fact that the people of that place have been donated some acres of land for development of that hot spring. So also, it was also raised question before the parliament regarding renaming of the regarding the name of the hot spring as Tarabalu, my lord. There is that. And in the meantime, my lord, the petitioners have also submitted representation before the authority, that is Collector Noyagar, for not to change the name of the hot spring, and that is pending till date, my lord. But my lord, my humble submission before your lordship is that if your lordship dispose the writ petition to dispose the representation pending before the authority, that is also correct, my lord. But keeping in view that the notification basing upon which order notification was issued, that has been set aside by this honorable court in writ appeal, my lord. So that notification doesn't stand, my lord.
Want to withdraw this writ petition, you withdraw it. If you think that the single judge's order is more than sufficient for you, withdraw this writ petition.
No, sufficient. That is, my lord, bad in the
all right. You say the challenge in both these petitions, if the direction sought in both these petitions to the opposite parties not to change the name of the single score Tarabala Hot Spring.
I'm in fast item, madam.
So you are one. You say it should remain as Tarabala.
Tarabala.
And he says it should remain as Nilakanta Hot Spring.
As the land situated in the village Nilakanta Prasad.
These are two petitions raising the issue of how the hot spring located in the Nilakanta village. Nilakanta Prasad village. Also should be named. Stop. While the petitioners in writ petition civil PIL 16645 of 2017 wanted to remain as single quotes Tarabala Hot Spring, unquote. The petitioners in writ petition civil 19235 2016 wanted to be changed to single quotes Nilakanta Hot Spring.
Yes, ma'am.
Unquote. The court does not see that these are issues which should be entertained in a PIL by the High Court. And this is entirely a decision for the government to take based on the exigencies and local factors, which the government is in the best position to assess. Consequently, the court would not like to entertain these writ petitions and they are disposed of as such.
Supplementary list item 32.
Appearance of union noted in this case.
Yes.
Item 32. This is a PIL matter. The petitioner challenging the illegal distribution of ration cards in favor of moneyed and influential persons, households.
You can go to the Lokayukt, sir, for all this.
My lord, kindly have a glance to the last order. Order number 15. The court has directed the secretary Food Civil Supplies to inquiry and submit the report. And a report submitted by the learned counsel for the state is not proper report. Appropriate report shall be filed by the next date. And for the last 2 years, they are not filing the report, my lord.
So you can file further reports in the Lokayukt, sir. You say for the issues raised in the present petition, it will be open to the petitioners to approach the Lokayukt. In accordance with law, the pleadings in the present petition can be relied upon. The pleadings and orders passed in the present petition can be relied upon in those proceedings. Stop. The petition is accordingly disposed of.
Supplementary list item 33.
Well, in Mouza Badhuda, there is a playground that is 80 acre 60 decimal and a rural land and also a development land that is meaning more than 30 acres land, my lord. Now the playground has been totally enclosed by the other persons, my lords.
Who's the other person?
Other person, including some institution, is there, and also private persons are there.
Sir, where are they? What opposite parties are they? Have you implemented them?
Yes, madam.
No, only one college you've implemented.
College is only opposite.
Well, my grievance is that, my lord, in 2000, a mistress number 680/2000 a 5-acre 88 decimal was in possession by the opposite partner of 5 the college. And again, in 2018, he has filed a demarcation and subsequently obtained an order from this honorable court to demarcate the land. After demarcation, another vacant land of 5-acre 88 in playground has been allotted to the college minor. Subsequently, the Tahsildar submitted a report regarding encroachment. In first PIL, he has submitted that the college has no encroachment. Now he has submitted that 6 acre 40 decimal has been encroached by the college minor. In meantime, this honorable court in order dated 13/5/2019 has directed to inform the concerned authority to remove all the encroachers, including if the present petition is an encroacher, my lord. In meantime, but thereafter, the Tahsildar has leased out the process, filing a lease compliance affidavit to leasing the institutions to time, my lords. Therefore, my grievance is that the playground is more than 18 acres. This is now has only 3 acres, my lord. At the village playground, my lord. That the total government land has been encroached in 30 acres lands. Now it is physically has 3 acres or 4 acres, my lord. Till today, in first PL, the revenue officer has submitted that no encroachment. And now he submitted that is the encroachment. And the one vacant land was, I have submitted my lord, the order dated mistakes. The order dated in mistakes number 680/2000, that is categorically stated that the college has possession of 9 acre 25 decimal, including the 5 acre 88 decimals, which was claimed for demarcation, my lord. Another the Tahsildar submitted provided the vacant land, my lord.
Yes, Mr.
My lord, I am appealing.
Kindly see the compliance affidavit dated 27th November 2019,
In the first writ petition.
filed by the Tahsildar Kanika.
In the first writ petition.
Yes, in 9629 of 2018.
Counter or compliance?
Compliance affidavit, because so far as this eviction is concerned. Para 2, I'm sorry, page 2. The detailed status of the evicted encroachers given below for reference. I have given the details who are the encroachers and they have been evicted. That out of the above 8 numbers of encroachers, serial number 4, 6 and 12 were evicted as per OPLA Act from government land Mauja Swanso, plot number 3, but there is public objection in respect of institutional encroachments from serial number 5 and serial number 7 to 9 mentioned below. Serial number 5 is Ladies Hostel, SN College, Rajkanika. 7 is Satyanarayana Club. 8 is Baghodwa UGP School. 9 is Athletic Association Baghodwa. That notice was issued to the above encroachers for eviction from the said land, but the 4 numbers of institution again submitted application for alienation proposal in proper forum. The present status of the alienation proposal are under process. Alienation, so we are under the process of alienating those.
This was in 2019, sir. What is
my lord.
What is the current position? 3 years have passed.
I think that is the last affidavit submitted by.
Madam, my grievance is that the 5 acre 88 has been acquired by the college in 2000 as per the mistakes number 680/2000. I have showing the filed the order, my lord, the mutation order. And now in 2019-20, the same revenue officer has allotted a vacant land of 5 acre 8 decimal, my lord. That is the grievance. Immediately, others are encroaching the school, clubs, and other persons are also encroaching. Till no encroachment proceeding initiated. As per the order of the eviction order passed by this honorable court, encroachment proceeding are initiated against the institution and others. In meantime, the college has encroached 6 acre 40 decimal, my lord. My grievance is the vacant land also allotted in.
My lord, I am appearing from the college, my lord. 10 acres of land has been leased out in favor of the college in 1980, my lord. We filed a demarcation proceeding. These PIL petition are objected because he is a regular habitual land grabber, my lord. He has encroached the government land, my lord.
Actually,
we agree. We agree that
he is a member of that village, and some institutions are, whatever we can say, encroachers are there in occupation since long. And we are planning to alienate it, and this is the status. And he is not tolerating all these things, and he is trying to evict all, even if the college is there.
So, I am not disputing the college land, my lord. My grievance is that even the college has acquiring the 5 acre.
Encroacher, why should we entertain your petition at all, sir? If you yourself are encroaching,
My lord, I have not I have done the enclosure.
You have filed an affidavit saying it's an
my desperate submission, my lord.
Which is your affidavit?
No, my desperate submission.
1 minute, sir. Let us find out.
Now
1 minute, sir.
Sorry.
Para 6 of my counter affidavit.
In which petition?
Page 2, my lord.
No, which petition?
The counter affidavit in first writ application. Number. Writ application number 9629 of
9629.
You are respondent number what? Opposite party number?
5, my lord.
5. Where is that?
At para 6, page 2. Seventh line from the top.
Habitual land grabbers. Has he filed a rejoinder? He's filed a rejoinder. Let's see what he says in that. You say there you have no comment to offer. Your rejoinder.
My lord, I have comment that, my lord, I have honest, my lord. Initially, in name of my father, 112 decimal land has been showing an encroachment.
So then this is obviously a fight between two sets of encroachers.
No, my lord,
this is not public interest, sir.
Yes. My lord, when I am filed this petition, my lord,
public interest.
It's not PIL. It is he is a local man.
No, fighting more, my lord. More my lord, please, more nar con mujhe file chali case, more nar convert kar diya.
English record.
When I filed this PIL petition, the encroachment of my father has been converted to my name, my lord. That is the
you not come with clean hands, sir. You have not come with clean hands.
Therefore, this honorable court has passed in 2019. If the petition is encroached, I have evicted, my lord. But my lord, that is the 118 acre land of the playground has been encroached by others. If you want to raise the someone
direction that they should proceed logically in all these encroachment proceedings, take it to the logical end.
Therefore,
including the petitioner.
Any direction may be given to the collector, Kendra.
Correct.
He will look after all these things, and after hearing all the stakeholders, he will take necessary.
Grievance of the petitioner in all these petitions.
Just close the playground of
regarding alleged encroachments.
Playground of the college, your college.
That is not playground of college.
Made in land located in Bhagabuda village of Kendrapada district.
Yes, ma'am.
Yes, ma'am.
Under Kanika Tahsil.
Under Kanika Tahsil. To an extent of almost 10 acres. Full stop. According to the petitioner, the land has been classified as Kisam Playground, Gochar and Gramya Rasta. And it has been encroached by the respondent opposite party number 5 college in writ petition 9629 of 2018. Paragraph. In response to the said writ petition 9629 of 2018, a preliminary counter affidavit is filed by opposite party number 5, in which inter alia it is pointed out that the petitioner himself and some of his open quotation henchmen, unquote, are open quotation habitual land grabbers, unquote, who have tried to encroach upon the land of the college and have raised a dispute with regard to the boundary of the land in question. Stop. It stated that the college accordingly applied to the concerned Tahsildar for demarcation of hull plot number 703 of 888. And when no action was taken, writ petition civil 7935/2018 was filed at this court. Full stop. In the said writ petition, an order was passed on 14th May 2018 with a direction to the Tahsildar to complete the demarcation process. Paragraph. On its part, the compliance affidavit has been filed by the Tahsildar Kanika, listing out the steps taken to evict encroachers. Stop in para 4 of the said affidavit. The details of the 13 cases of removal of encroachment have been set out. Stop. Eight of the said encroachers are stated to have been evicted, but there was public objection in respect of the institutional encroachment, as indicated in serial numbers 5 and 7 to 9, which is the opposite party number 5 institution and its allied institutions. Full stop. Paragraph. Inasmuch as the allegation against the petitioner himself is that he is an encroacher, the court would not like to entertain the present petitions at his behest. So at the same time, there is obviously an issue concerning encroachments, which the Tahsildar admits in his compliance affidavit, filed on 27 November 2019. Full stop. Consequently, a direction is issued to the Tahsildar, to the collector, Kendrapada, to review all the cases of encroachment as mentioned in the above affidavit of the Tahsildar dated 27 November 2019. And wherever the encroachment proceedings are still pending, to complete them in accordance with law within a period of 12 weeks from today.
My lord, in some cases, we are proposing to alienate the land in favor of the encroachers.
The disposal of the encroachment cases did not necessarily end in eviction, but where the proposal is to alienate the land in favor of an institution, that be taken to its logical end.
Yes,
in accordance with law. Paragraph. If any of the members of the public is aggrieved by those decisions of the collector or Tahsildar, it will be open to them to seek appropriate remedies in accordance with law. Also, it is made clear that such grievance would be entertained only at the behest of persons who are not themselves encroachers. Full stop. The petitions are disposed of in the above terms. In view of the order passed today, contempt petitions also disposed of.
My only my grievance is that I have announced in the affidavit that is the order passed in Mr. number 680/2000. And 25/5/2000.
May I request that this order may be communicated to the collector?
Copy of this order be sent to the collector forthwith for compliance.
Well, my parent to mention that in 25/5/2000, in mutation mistakes, the 5 acre 88 decimal is possession by the college, my lord. That had been looked at what the collector, my lord, that is only the take care of it.
Yes, collector will.
My lord, that is the mention, my lord. So it more to us, now the Tahsildar allotted is a vacant land, similar area, my lord. That is the my grievance, my lord.
All right.
My lord, that is the meant to mention, my lord, in order, my lord.
Whatever, sir, we've dictated. All right.
My lord, that is the important ground, my lord. That is the playground has been totally enclosed by
let him look into it, sir. Let him look into it.
Supplementary.
My lord, that is the order of the Tahsildar, my lord. That is therefore I am.
All right. All right.
Item 34.
A liberty to file even an objection, my lord. That is the my mention, my lord.
All right. Yes.
Item 34.
I am appealing for the petitioner minors to the filing worker because the on transfer of the grip minors. Yes, I must fairly concede my lords. There are so many prayers relating to passing of the advertisement for sale of SESU, cancelling the agreements of distribution franchisee under the erstwhile SESU minors. So far as all these prayers are concerned, they have become infructuous minors, except the prayer number 3 at page 38 minors, which relates to financial irregularities.
You approach the Lokayukta for these pensions.
So what
counsel the petitioner seeks to press only for prayer number 3
suggest minors, one moment.
regarding financial irregularities committed by the authorities of SESU. For such grievance, it will be open to the petitioner to approach the Lokayukta in accordance with law. The petition is accordingly disposed of.
Supplementary list item 35.
Let me kindly see the order dated 23rd August 2021. That was almost 1 year back. We are giving a convenience note for today, but if my lords would see page 4, paragraph 8 of that order, it was regarding these toll-free helpline numbers.
Yes, yes.
The rule 5 of the 2020 rules that has been quoted.
Yes.
And if my lord would see, it says the government shall set up an internal grievance mechanism for disposal of the complaints, resolution of queries, and providing information relating to provisions of the Act. So all 4 schemes are there. So what they have done is they are again sticking to that TPDS. Other 3 schemes are just given a go by. And even my associates called today also, those numbers are not working, man. This is almost a year. Detailed directions were given, paragraph 9 and 10. A turnaround time was fixed. It was said that they have to upload everything in the website. Now, in fact, to be fair to them, the website is itself dated, my lords.
Lordship, I have received the convenience note which my lord in friend has given my lord. We had earlier filed an affidavit, which was, my lord, in the month of 5/1/2022. In view of the convenience note my lord in friend has filed, my lord, I will take instruction on some of these areas where he finds that we have not done the compliance completely, my lord. There is an incomplete compliance. So if the lordship allows me, my lord, I'll file an affidavit with regard to that.
Convenience note has been submitted by the amicus curiae, pointing out to the incomplete compliance of the orders dated 2nd February 2021, 24th March 2021, and 23rd August 2021, passed by this court. A copy of the note has been handed over to Mr. Tripathi, learned counsel for the state, who seeks time to examine it and seek appropriate instructions. It is impressed upon the state that there must be complete report of compliance with the directions issued by this court in the aforementioned orders. An affidavit of compliance be filed dealing with all the issues raised in the note submitted today by the learned amicus curiae. The affidavit be filed at least 1 week prior to the next date with an advance copy to the learned amicus curiae. List on.
I'll pray for a short date only because that's.
I think 22nd September.
Okay. I'm ready.
22nd September.
Let them also that the DGROs, they have empowered to look into this suo motu.
Correct.
The people who are left out, they can on their own take up. So many things could be done. I think Mr. Tripathi knows how the government functions. So.
All right.
Supplementary list item 36.
We agree.
Government is functioning.
None appears dismissal not as question.
Supplementary list item 37.
Yes, none appears dismissal.
Item 38.
None appears dismissal not.
May it please, my lord. Appearing to VC
Yes.
On item number 38.
Yes.
All of a sudden after 2020, my lord, it got listed for the first time. My lord, on the last occasion, it was 20th January 2020, which it was listed last time. My lord, a week's time. My lord, I am the one who was handling the matter. A week's time may be given. I'll have to take instructions as to whether we still need to go ahead with the matter or it has become infructuous. There are certain provisions under the MMDR Act and also under the rules that we challenge. So therefore, my lord, may kindly grant me a week's time or any fixed date if your lordship can indicate for this matter.
Every date is a fixed date. Today is the fixed date, sir.
My lord, I got
firmly fixed for this matter.
My lord, last night, my lord, I got to know. Please understand my predicament and appreciate my lord, please. That is my request, my lord. I'm not shying away. I'm not running away. Everything, all documents and everything is there, but I need to discuss the matter. I need time, my lord. I need a week's time to get back to your lordships.
Virtually, it is infructuous, my lord. Virtually, it is infructuous.
My lord, there is an order.
8A as well as this rule 6, and after amendment, that nothing is left.
Oh, this is pre-amendment, is it?
Yes. Yes.
No,
yes,
it is not pre-amendment.
There is filed in 2019, but the prayers in respect to Rule 6(4) of this prayer 2, let's see. Rule 15, they have asked for ultra virus.
My lord, on the last occasion, the 2nd of January order, if your lordship could see the order, under which, upon the request being made by the state government, this Honorable High Court has given a direction that you may very well go ahead with the allocation of the mines, but whatever allocation will happen, the same will be subject to the outcome of this petition, even though your lordship's predecessor was not inclined to give a blanket stay of the operation of the NIT, the impugned NIT. However, this order was specifically passed so that whenever this or the issues raised under this petition, that will be subject to the outcome of the matter.
No, 1 minute. Who are the persons who have been given allocations?
That list, my lord, there's a lot of mining areas, my lord, that I have to get back to.
No, this is for all over the country.
No, my lord, these mines, these minerals in question, which all developers or which all companies were the ultimate successful bidders and which all were the ultimate allottees, that I need to bring it on record. Or else,
suppose there are 100. 1 minute, sir. Suppose there are 100 such companies, you will implead all of them now.
No, I will not implead, my lord.
How? Without impleading, how will you proceed in the matter, sir?
My lord, since your lordship has asked me that who all are the allottees, my lord. My lord, may kindly grant me a week's time, my lord.
You kindly answer this.
My lord.
Suppose we were to allow your writ petition, will it affect all those persons to whom allotments have been made, or it will not?
It will affect, my lord.
So do we need to know who they are, and should we not hear them?
Yes, my lord.
If they are 100 in number, what do you propose to do? That you will implead all of them? They'll all 100 people will file counter affidavits.
No,
and we'll sit and decide that.
There are not.
And we'll sit and decide that.
No, my lord, that is not the number. 100 is a very high number, my lord. I don't think there are more than 5 to 10 people, those who have been.
How do you know? How do you know, sir? No, and this is not confined to any one particular mineral. This is applicable to all the minerals.
My lord, the blocks at page number 12, my lord, in a tabular form, my lord, I have provided the number of blocks. There are 11 blocks, my lord. 11 blocks. Iron ore blocks, iron ore and manganese blocks, which were put to auction by virtue of that tender, that impugned tender, my lord. 11 blocks would not be allocated to more than 11 persons at max, because the consortium was also not allowed. So therefore, my lord, my only request.
You do one homework, sir. You first do your homework properly. You find out to whom it has been allotted. You find out what you want to challenge. Then you file a better petition. That's far better.
No, my lord,
dealing with one omnibus petition like this, which will take you nowhere, it will take us nowhere.
My lord, there is no difficulty with my petition. My lord, please appreciate 2019. After the NIT was published, I immediately filed this case. Your lordships have been kind enough to admit this petition after bringing on record additional affidavits. Thereafter, only being convinced and only after making my submissions, your lordship's predecessor has passed the order 2nd of January. Madam, may kindly have the 2nd of January order. Madam, may kindly have the daily order passed on 2nd of January, in which the order, after hearing the matter, may I read the order of 2nd of January 2020. Learned Central Government Council request for time. Matter to come up on 3rd February 2020. In the meantime, we make it clear that the tender process is not stayed. However, allotment, if any, made thereto shall be subject to the result of the writ petition. Issue urgent certified copy of the order on proper application.
1 minute, sir.
My lord, Corona happened, then the matter could never be listed.
So this is not an elaborate judgment or anything. It's a 2-line order simply saying that whatever allotment will be made will be subject to the outcome. So at this stage, on 2nd January 2020, allotments have already been made.
No, my lord. The tender was under process.
So
it was not
whatever the facts, it was duty bound on your part, knowing fully well that there were going to be allotments. You should have taken steps to implement all those successful bidders. You never took any steps. You never even bothered about this petition, sir. It has come up on its own.
My lord, it has come
You've not taken any steps, which is why we are saying if you're still aggrieved by the allotment made to anyone, you file a proper petition, setting out all those facts, making them parties, then we will see whether we should entertain it at all or not.
Because my
lord, you have
lord,
not been diligent. You have not been diligent in pursuing the petition.
My lord,
This court specifically told you there are going to be allotments and those allotments will be subject to the outcome, correct?
My lord.
Despite which you did not move your little finger.
After that,
so we are not here to entertain petitioners who are not serious about their petitions. Sorry.
My lord, may I say one thing, my lord?
Yes.
After the matter was listed, matter was filed, back to back the matter got listed. And for the admission of the matter.
Sir, I have been here for the last 1.5 years. Mr. Mishra, I have not heard you mention this writ petition even once.
I bow down to that.
Yes, yes. So let us be clear about some of these things.
Yes. Yes. I am not disputing those
things.
So
we are not even taking away your right to file a fresh petition if any cause of action survives. That's the highest we can possibly say, because we are not even clear whether we are serious about this petition at all or not. You say this petition was filed in 2019. Questioning a notice inviting tender dated 6th December 2019 as being contrary to the provisions of the Mine and Mineral Development and Regulation Act 1957. Full stop. While notice was issued in the petition on 12th December 2019, on 2nd January 2020, it was made clear that the tender process is not being stayed. However, open quotation, allotment, if any made thereto shall be subject to the result of the writ petition, unquote. Paragraph. Thereafter, this writ petition has not even been listed once in the last more than 20 months. Stop. In its own turn, it has come up for hearing today. Paragraph. When the petitioner was asked if any steps had been taken to ascertain who the successful allottees were and whether they've been implemented as parties to the writ petition, the answer was in the negative. Stop. This raises serious doubts whether the petitioner is serious in pursuing the petition. paragraph, considering that there must have been allottees by now pursuant to the NIT in question, it would be open to the petitioner, if after ascertaining who such allottees are, if such allotments still required to be challenged, to file fresh petitions, including with proper pleadings, making such allottees parties to the petition, and to seek appropriate reliefs in accordance with law. Stop. The petition is accordingly disposed of.
Supplementary list item
number 1 and 2, my lord.
All right.
Item 39.
39.
My lord, so item 39 may I please receive? I mean virtual, my lord. This matter has been infructuous, my lord.
All right. Council petitioner states the petition has been rendered infructuous. Disposed of.
Item number 40.
None appears dismissed non possible.
Item 41.
None appears dismissed non possible.
Supplementary item 42.
42, I am appearing, my lord, for the petitioners. In both the connected writ petitions, my lord, the virus of Rule 9.3 of the Orissa Registration of Births and Deaths Rule 2001 is challenged, my lord, being ultra-virus to Section 30 of the Parent Act, my lord, Act 69. So also, my lord, the said rule also contravenes the provisions of 13.3, my lord. So no counter act has been filed by the state, my lord. The virus of the rule has been challenged, my lord. Despite the liberty has been given to file a counter, my lord. The Rule 9.3, my lords, extends jurisdictions of magistrate first class and presidency magistrate to a executive magistrate, my lords, which is per se contrary to the Parent Act. Parent Act only says, my lords, magistrate first class and presidency magistrate has the jurisdictions, my lords.
How does it affect you?
My lord?
How does it adversely affect you, sir?
It adversely affects, my lords, because, my lords, because of this executive magistrate passes a order to directing the registrar of the births and deaths to register to find out the death certificate, to get a death certificate and birth certificate, my lords. Here, executive magistrate, lots of cases, my lords, after the when land has been sold by the predecessors, of the legal heirs, my lords. What happens, my lords? After 10 years, 20 years, they get a certificate of backdated that their parents have been, or father has
that
been.
Is nothing to do with, that is nothing to do with the virus of the act, sir.
Yes, ma'am.
You are now on the virus of the act, not about the misuse of the provisions.
Let's kindly do the virus of the act, my lords. Virus of the act, my lords, let's kindly see 9.3, my lords. 9.3 at page, my lords. Let's see, may kindly see page 21, my lords. 9.3 of the first writ, my lords. Any birth or death which has not been registered within 1 year of its occurrence, my lords, shall be registered only on an order of a magistrate of first class or executive magistrate or a president's magistrate and on payment of late fees rupees 10 in cash, my lords. These provisions, my lords, sir, let's see, may kindly see section 30 of the Parent Act, my lords. That is, my lords, at page 17, my lords. Page 17 of the same writ, my lords. At the bottom, my lords, power to make rules, my lords. The rule making authority has been given to the state, my lords. The state government may, with the approval of the central government by notification in the official gazette, makes rules to carry out the purposes of this act. The relevant person is, my lords, G, my lords. 2G, surplus G, my lords. The fees payable for registration made under section 13. This authority has been given to the state government under section section 30, my lords, to prescribe the fee only in 13, my lords. Let's now come to the 13, section 13 of the same act, my lords, at page 15, my lords. Page 15. Page 15, my lords. 13, delayed registration of births and deaths, my lords. Any first clause, subclause 1.
No, you're reading only G, sir. Read F also.
Yes, ma'am. F also, yes. Let's see, F, the authority which may grant permission for registration of a birth or death under subsection 2 of section 13.
Right.
Subsection, let's come to 13, my lords. I am not concerned with subsection 2, my lords, of section 13. I am concerned with subsection 3 of section 13, my lords. Subsection 2 is okay, my lords, there is no problem. Subsection 3, my lords, says any birth or death which has not been registered.
So merely because, no, the rule adds executive magistrate to these two classes of magistrate. That's all.
Yes.
The rule does not exclude these two categories, sir. The rule simply adds one more authority, which is the executive magistrate.
Rule which is beyond the jurisdictions of the state.
How does it affect you, sir? How does it affect? What is resulting as a result? What is happening as a result?
I am, lordship, giving an example, my lords. In the second read, my lordship, kindly to the second read, my lords. That is a bright example how I am suffering, my lords. Lordship, I kindly see impugned order para page annex 11, my lords, as 84, page 84. Lordship, I kindly have a look. 84. Who has passed this order, my lords? Page 84.
So what? Whoever has passed, sir.
My lord,
what is the problem? That you have to do that.
Is, my lords, executive magistrate, it is easily to get an order from the executive magistrate, though the act prescribes to the magistrate first class, my lords, because there, my lords, the evidence and witnesses, everything has been examined. Here, the administrative order has been passed by the executive magistrate, directing the registering authority to issue a certificate, death certificate or birth certificate, my lord. So, in this case, what has happened, my lord? The father of my lord's opposite party has been sold on land. After
that doesn't mean that, sir, if there is an abuse, if there's an abuse of the process, we can certainly interfere on a case-by-case basis.
Yes. That is this.
You can't just strike down the entire rule itself.
Because judicial officers, your lordship knows,
entire rule
now they are workloads and they cannot take. That is why the rule has been framed that executive magistrates will do this. And I think there is no.
Let them have precautions. If you think that the executive magistrate should conduct an inquiry before granting this, we can say that they should conduct an inquiry.
They are.
Let them build in safeguards, sir.
Sir,
I think that will serve your purpose. Let there be a set of guidelines.
My lord, they are conducting the inquiry. They are examining the witnesses. That is, your lordship may see page 8.
How they can frame, my lord?
The same process will be adopted by the judicial magistrate. Only examination of witnesses. The no more thing can be, because it is death occurred 20 years, 30 years back.
Sir, please, lordship, kindly see. If the act doesn't prescribe, my lords, to add a word into the statute, my lords, how the state government will add, my lords?
Yes.
It's totally ultra to the provisions of section.
No, there is no prohibition in the act, sir. Just read the act carefully.
There is no prohibition.
There is no prohibition.
Lordship, kindly come to, my lords, 13.3, my lords.
Yes.
Any birth or death which has not been registered within 1 year of its occurrence shall be registered only on an order made by magistrate of the first class or a president's magistrate after verifying the correctness of the birth or death and on payment of the prescribed fees. The act prescribed to only magistrate first class, my lords.
Right.
How the state government will come with the executive magistrate, my lords, and what is not amended by the parliament. The parliament, in its best wisdom, has only mentioned is giving the authority to the magistrate of the first class and president's magistrate, my lords. Here, bringing the executive magistrate in the rules, my lords, which is contrary to the provision of section 13.3, as well as, my lords, the authority has not delegated, the power has not been delegated under 30 of the Parent Act, my lords. So that needs to be, my lords, take down, my lords.
Page 104, column 3. Paragraph 3, page 104, annexure 16. Any birth or death which has not been registered within 1 year of the occurrence shall be registered only an order of a magistrate of the first class or a executive magistrate or a presidency magistrate on payment
So
of
he's only saying, how did you insert executive magistrate in this? Because the act does not talk of executive magistrate, only talks of judicial magistrate of first class and presidency magistrate.
Yes, sir.
In the second petition, no notice is gone.
No notice has gone, my lords. The notice will be issued, my lords.
No, second petition, no notice has gone, sir.
No notice has gone.
Those affected parties are not, the affected parties have to be put on notice then.
Yes, ma'am. So only one party is there, private party. That notice, I'll take speedy post, my lords. Only opposite party numbers 5, my lords.
No,
5 and 6.
6 also.
5, 6 also, yes, my lord. 5 and 6, I'll take speedy post, my lords.
In both these, just put down both these petitions together. A short question to be answered. The short question raised for determination by this court is whether Rule 9(3) of the Orissa Registration of Births and Deaths Rules 2001 is ultra vires Section 13.
Section 30 and 30.
Bracket 3 of the Orissa of the Registration of Births and Deaths Act 1969, bracket Act, inasmuch as under Section 13, bracket 3, the registration of a birth or death beyond 1 year of its occurrence can be open petition only on an order made by a magistrate of the first class or a presidency magistrate after verifying the correctness of the birth or death or on payment of the prescribed fee, unquote. Whereas Rule 9, bracket 3 of the rules permits, in addition to the above two authorities, even an executive magistrate to pass an order in that regard. Paragraph in Writ Petition Civil 6733 of 2020. One such order passed by the executive magistrate on
16th September 2011.
Yes.
On 16th September 2011 is under challenge. In Miss Case number 996 of 2011 is under challenge.
Yes.
Paragraph. You say, well, notice has already been issued in Writ Petition 2983 of 2020. It is yet to issue. It is hereby issued in 6733 of 2020. Mr. D.K. Manthi Learned, AGA accepts notice in the second petition on behalf of the state authorities, and Mr. P.K. Padi on behalf of the Union of India. Bracket opposite party number 7. Full stop. Notice will now be issued to opposite parties 5 and 6 through registered speed post returnable. On the next date, the tracking report will be placed in record. Replies to the petition be filed by the opposite parties within 4 weeks of service and rejoined before the next date. List on 13th December. Right.
Much obliged.
Supplementary list item 43.
Already in purchase.
Answer the petition says the petition rendered it is disposed of as such.
Permitted to withdraw.
All right.
First case withdrawn.
First case is withdrawn, second case is infructuous.
43. Supplementary list press admission item number 44.
44 ballot permitted to withdraw ballot. Counsel the petitioner seeks leave to withdraw the present petition. Dismiss as withdrawn.
Item 45.
45 is also infructuous, but the same may not be pressed anymore.
Okay, and not pressed. It's disposed of.
Supplementary list item 46.
46, my lord. Today I received the counter affidavit, my lord. I want to file rejoinder kind of one time.
What is the matter about, sir?
Matter
the counter affidavit, we have already said that there is no cause of action for the petitioner to proceed with this.
But because, my lord, what I beg to submit, my lord.
Where is the counter? Is not here, sir.
Today received the copy, my lord.
Counter is,
but
we have
in fact, my lord, another person went to the Green Tribunal, my lord. There is an order has been passed.
Oh,
their
then
stand is different. I think that their stand in the Green Tribunal difference. They are taking the plea that since the writ application pending before the National Court, my lord, adjudication for that, then there the matter
Then your lordship can dispose it of. They will pursue the NGT matter.
No, that NGT dispose of my instruction that has been disposed of, my lord. For that is I want to file one rejoinder.
All right.
One type.
Counter affidavit of the opposite parties be brought in record. Rejoinder be filed for the next day. List on 17th October.
Passover item 2, lordship. Passover 2.
1 minute. We'll reach the end.
Item 47.
None appears dismissal opposite.
Item number 48.
My lord, in view of the order dated 2/5/2022, this matter was listed before this honorable court as the matter is PIL in nature, my lord. My lord, the matter is relating to, my lord, the opposite party number 1/5 by producing undervalued solvency certificate is eligible to get the 2 numbers of sand quarry for a period of 5 years from the 2 Tahsil office, my lord.
Why is it listed?
In this regard, I have given the repension that is under Annexure 3, my lord. A limited grievance, my lord, the Annexure 3, my repension is pending.
All right. The petitioner's representation dated 28/9/2021. But where is the proof of it? Okay. Be examined by the collector.
My lord, my lord. Tahsildar Anandapur and Tahsil Champua.
Oh, there are 2 Tahsil.
Then
There are 2 Tahsil, so collector will be
by the
better.
collector given here, and after notice to the petitioners as well as opposite party number 5, and after receiving inputs from both opposite parties 3 and 4, will pass a reasoned orders not later than 1st November 2022. Said order should be made available to the parties not later than 8th November 2022. The court clarifies it is not expressed in the matter.
Item 49.
Obliged.
When did this acquisition process take place?
May I please, your lordship?
Now, when did this acquisition process take place?
Pardon?
When did this acquisition for Paradeep Phosphates, when did this acquisition take place?
It was on...
When was the Section 4 notification, if at all? When was the Section 6 declaration? When were the awards passed?
Kindly take a glance at Annexure 1, my lords. Notification.
Not like this, sir. Where are your dates? Where is your petition? Where have you set out these dates? And why should something that started in 1982, why are we dealing with it today?
My lords, there are the person of the locality who have been deprived of their legal rights.
No, deprived meaning since when, sir? When are you coming to the court? What have you been doing in the meanwhile? It's a 1982 acquisition. You're coming in 2022, 40 years later.
And no land loser is before your lordship.
Oh, this is PIL.
This is a PIL.
Why are the affected people not before us? Oh no, this is some Sangatna.
Navanirmana Krusaka Sangatana.
Anyway, so it's like a representative body. But why are you coming 40 years later?
My lord, they are the land losers, they are poor people and they have not...
Sir, poor people doesn't mean that you start entertaining something after 40 years and 50 years. There has to be some explanation.
Some of them have approached the honorable court and get redresses, but most of them are...
Sir, what is the time? What is the explanation of the delay? Give us a proper explanation of the delay. If some of them could go to the court, why did the others not go? You have to give proper explanation.
According to him, some of the land losers have already addressed their grievance before this honorable court and matter has been disposed of. So this is...
Where is that? Where are those orders?
One of those order is there.
At the annexure?
At annexure. At annexure 4A.
Sorry?
Annexure 2 series, my lord.
How can
running plus 47.
So how can you suddenly club everything? Which page is this? 2000, AIR 2000 Orissa.
2000 Orissa.
22 years ago, sir. Where were you people for the last 22 years? You're suddenly waking up one fine day and saying, let's now go to the High Court after 22 years.
The pleadings are not clear even. What is the real grievance of the petitioner?
My lords, the grievance already have been stated in the petition.
No, you're simply saying they are land losers, they've not got compensation. This is neither here nor there, sir. You should actually systematically say, were your lands covered in that notification? Do you figure in the award? What steps were taken? You have to do a proper research.
My lords, the grievances have already been my lords, liberty may kindly be granted to move before the collector.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the collector in the first instance with the proper representation, setting out the full particulars. And after following up on such representation to seek appropriate remedies in accordance with law. The petition is disposed of with liberty is granted.
Supplementary list item number 50.
Well, so many defects. Full of defects.
This case 50.
The bookmarking is not proper. See the writ petition, prayer, nothing is there in this bookmark. Some representation here also. Where is the representation, sir? Prayer 1 is about representation.
Annexure 1.
Annexure 1.
10th January 2022.
But nothing to show it is delivered. So what is that to show it's delivered to the collector? No proof of that delivery. Who is appearing for the petitioner? Pass it over once. Pass over.
Item number 51.
May I please, your lordship?
Yes.
This is the PAL. The petitioners are the elected members of Kasipur Gram Panchayat in the district of Raigada, my lord. Lordship, I would like to draw your lordship's attention on Annexure 5, page 45. As lordship knows, section 20 is mandatory. There is a public notice for issuance of fresh notice or renewal of a license of any excise year, my lord. That apart, section 27 is strictly applicable to the scheduled areas, my lord, where the prior to issuance of license, the consent of the sarpanch is necessary, my lord. Lordship, see Annexure 5, page 45. Well, this is the license issued in favor of OP number 5 for the excise year 22-23. Lordship will find they have written the valid from 1st April 2022.
Your parlor license.
Yes, my lord. 31st March 2023. Lordship may come to next page, page 46. This was issued by the collector of the licensing authority on 6th April 2022, my lord. In absence of section 20, my lord, there was no public notice. Then we objected. Lordship, say Annexure 1, page 18. On 21st April, public notice is issued after issuance of license, my lord. Then we objected, my lord. We filed our objection along with the resolution of the Gram Sabha as recorded under section 27.
For those objections, the decision of the Tahsildar not to issue the license?
My lord, what happened? We approached government also. Annexure 4, lordship is fine, page 45.
Yes.
Specifically, the government has directed concerned collector to inquire into the matter and submit the report. Till today, they have not taken any tangible steps, my lord. My grievance is only let collector be directed to inquiry to the matter, my lord, because you have filed our resolution within the date, my lord.
No, but without hearing opposite party number 5, we can't pass those directions. He's already been issued a license.
Annex
And
page 44.
the license was issued since 1st April, 6th April or valid from 1st April. They are coming after 4 months.
No, my lord, we have given objection, we have given to the government, we have approached that page 44, my lord.
No, objection was after the license or before?
Before, my lord.
All right, just say notice, Mr. Mohanty accepts notice. Notice to opposite party number 5, the registered speed post. Opposite party, sorry.
Private opposite party maybe.
OP number 5.
5, yeah. By registered speed post, tracking report will be placed on record for the next date. You say list on 18th October. Counter affidavits be filed within 4 weeks of service of notice. Rejoinder for the next date.
All right.
Supplementary list item 52.
You want equal weightage for both
My lordship.
class 11 and class 12.
My lordship.
What is the basis for this prayer?
My lordship, the basis arises on the point that CBSE had earlier issued a notification that if the exams are conducted in schools, then equal weightage will be given to both the exams. But after the results have been published for class 10 and class 12, at that time they are publishing that we have changed the basis and now we have adopted a 30-70 selection marks weightage. My lordship, when the examination for term 1 and term 2, the syllabus itself was divided into 2 parts, 50% in term 1 and 50% in term 2. At that time, they had already asserted that there is going to be a 50-50 weightage. In the meantime, also, a circular was issued on Twitter that 30-70 is going to be adopted by the CBSE. At that time, also, they again posted on Twitter that this is a false circular getting circulated. And finally, my main point over here is that there is an established principle of law that the rules of the game cannot be changed once the game is over, which was held by the Apex Court in the case of, my lordship, in page number 8, I have the citation in K. Manjushri versus State of Andhra Pradesh, 2008-3 Supreme Court case.
Those are for selections. Those are for selections. It's not for declaring results because
it was the criteria.
No. By this time, by the time that the press release, what is the impugned press release? That's at Annexure 7.
My lordship, there are 2 press releases. The first one is in Annexure 2, which is in page 23.
But that's a 2021 circular.
That was the first one for 2021-22. That was the first press release where it was stated, and in page number 26, it says, in case the situation of the pandemic improves and students are able to come to schools or centers for taking the exams, the board would conduct term and term 2 examinations at the schools and the theory marks will be distributed equally between the 2 exams. This was clearly stated. And the examinations were held in school. But later, which is in Annexure 6, July 22, 2022, it's in page 29.
39.
My lordship, page 42, running page 42.
Yes.
Where they say, the predominant feedback received after term 1 exams was that students were unable to perform to their full potential in the term 1 examinations. And based on this, then they come, which is in the second paragraph, where they say majority of the members of the committee recommended that the weightage for term 1 should be around 30% and term 2 should be 70% respectively. My lordship, this comes in after the results are published.
No, let's read what they say above that. The predominant feedback right from the beginning.
May I read it aloud?
Yes.
The predominant feedback received after term 1 theory exams was that students were unable to perform to their full potential in the term 1 examinations as they had to appear for an objective pattern for the first time in board exams without any adequate precedent and practice. The predominant feedback for term 2 exams was more positive, with satisfactory performance being expressed by the students. The board sought the views of a large number of school principals and officials through a consultative mechanism. on the relative weightage to be given for the two terms to arrive at a composite final result.
So what is wrong with this? See, the point is they're trying to see how it will benefit the students the most.
My Lordship,
if a majority of students have not performed well in term 1 and relatively performed better in term 2, and they want to help students to score overall a better percentage, what is wrong with this?
My Lordship, but with this procedure also, there are a set of students who are going to get aggrieved. My Lord, another point why I have, what I wanted to mention here is, this is also violative of Article 14, where it is not equally treating the students. The total marks for term 1 and term 2 might be the same for two students. But if that student has performed better in term 2,
that is one instance. Let us say a majority of students, this is what they're trying to argue here. A majority of students have done better in term 2 than term 1. Will not it benefit a large majority of students to have this changed percentage of weightage?
My Lordship, but there are still again...
This is what a policy consideration is about, right? This is really a policy they've changed, and they've decided because of the experience and feedback they're receiving. They declared something in 2021 July. They've received feedback from parents, from colleges, principals, all of them, who all have felt that it's better to go for a percentage of 30-70 for term 1 and term 2.
My Lordship, they have the autonomy to come up with a policy, but at the same time, my point was coming up with this after the result.
So they've done it only for theory. Just see this, as far as practicals are concerned, equal weightage.
Yes.
Because in the theory, they introduced for the first time in term 1, the objective type questions. So students were unfamiliar with it, and therefore they were struggling, and therefore did not perform well.
My Lordship, about...
See, it's not a whim and fancy, right? This is not that arbitrarily they suddenly decided that, okay, well, let's do 30-70. They did it through a consultative process.
Even if that was made aware to the students that there is going to, that this...
See, what might happen in this kind of a PIL is this. You will have one set of students who are going to benefit, large set of students who are going to benefit by this change, going to be aggrieved.
Okay.
So when you have a PIL like this, is a problem. We can't possibly address them. And we're looking at CBSE, which is for the entire country.
My Lordship, there are students from outside Orissa also who are reaching out.
That's right. That's right. So there will always be, see, whenever you draw a line somewhere and you try and change something, there'll be people who are agreed by it, people who are for it.
Some
you can't
steps
try and
should be
satisfy
taken.
everybody.
In this case, some steps or measures should be taken.
See, it's
at
like
least for
moderation.
students.
Moderation, you always apply moderation after the exam is over, right? Then you find relative performance. They have what is called a bell curve. I don't know if you've heard of that.
Bell curve, yes.
So they try and moderation to see what is the overall percentile of performance. And they do add marks so that many more students can make the cut. So this seems to be that kind of an exercise. They've got a feedback after this theory paper of term 1, which is why practicals, they're not changing it at all. Because obviously the method of evaluating the practical was not changed. It's only theory, they introduced an objective pattern.
But at the same time, my lord, for term 1, which they are saying is objective pattern, the students got a time period of 7 months to prepare for term 1, which was held in November. So from March, April till November, they got the time. But term 2 was in March, from November till March. So at least around 3 to 4 months they got for term 2.
And yet they perform better in term 2. This is something which we can't dispute, right? Satisfactory performance being expressed by the students.
But a student who performed better in term 1, but the total marks is same as someone who has performed better.
No, there will be a small percentage. It can't be denied. There will be a small percentage of students who benefit by the earlier rule.
High Court can.
And a large percentage obviously will be benefiting by the second change rule. So where do we draw? Because after all, this is public interest. We're not dealing with individual cases.
My lordship, some measures or steps may be taken by the CBSE for these aggrieved students who approach them.
Who are those aggrieved students? Just give us even a sampling, then we can understand. Because this is again going to have ramifications throughout the country, right?
My lordship, this court, at least for the students in the state of Orissa might get a benefit.
We don't know. Even in Orissa, we don't know which students are going to benefit by the second change rule, or which students will lose out because of the change.
If I may be given another date, my lord, I can come up with a list of students who are aggrieved, because for the petitioner.
No, you have to be totally. See, if you start looking only for students who are aggrieved, you'll get a set of students. If you're truly objective, which is what a PIL petitioner should do, you should be able to have an objective view of, in a sampling of 100 students, how many are aggrieved by this and how many are not. That will be the correct way of approaching it. Otherwise, you're just bringing one point of view to the court. And in a public interest, that's a problem always. You can take your time about what you want to do, but you must be objective in what you do. Don't bring only examples of students who are aggrieved. That will not be representative of the entire student body. Because you are, after all, representing the entire student body, right?
Entire student body for Odisha.
So, yeah, you should not advocate the grievance of only a few of them.
Lordship, I can take a sample of...
See, you should have a consultative exercise. You are, after all, this Abhibhavak Mahasangha. So you can have a consultative exercise.
Lord, I may be given another chance for
all right.
coming
Say
up
at the
with
request of counsel to the petitioner. We don't say anything else. We've told you all that we are looking for. List on. Be in a month's time?
A month should be fine.
All right. 26th September.
Obliged, my lord.
All right. After lunch. After lunch.
May I please? Lordship, turn to page 46 in the input order.
What about the delay?
Sorry, much. Delay during the COVID period.
All right. Since the delay is explained on account of the
order back on 23 February
2021. Yes, which is the order? Impugned order now?
Page 46. At the admission stage, it has been disposed of. One matter your lordship has yesterday has passed.
Yesterday, same order. All right. Same date.
Supplementary item 54.
I may be granted 1 week time to remove the defect, my lord.
All right. Defects be removed within a week. All right.
Item number 55.
Please, Miller's.
This is item 55. The issue is that whether in the view of pendency of vigilance case, the promotion can be stayed, my lords. My lords, similar matters have travelled to the division bench and my lords have stayed those matters. In fact, the matters are coming up on 24th of November. So I'm giving those orders.
Lord, I have instructions to appear for the respondent in this case.
All right.
And we'll let him serve a copy of the appeal on me.
All right.
And this
delay is condoned, and then you say
there's no delay.
Well, the issue is in fact no longer the res integra.
Oh, why are there two interim applications then? Stay is one. No, delay is there.
Yes, yes.
My lords, the noting is that the delay is condoned.
Well, there is a delay, my lord.
There's no delay. You say there's no delay and dispose of. Yeah. Say notice, Mr. So, who is accepting notice? Somebody else will accept.
Yes, sir.
On behalf of the respondent.
Mr. GR Sethi will be appearing, accepting notice, my lord.
Right. Till the next date, the interim order, impugned order shall remain stayed. List on 24th November 2022, along with WA number 888 of 2021. All right.
Supplementary item 56.
That's item 56. My lords, will find the impugned order at page 22. My lords, again, my lords, there is a delay, but the delay has been condoned in view of.
All right. Delay condoned. That application is disposed of. Dispensing filing of that is also allowed.
Please, my lords. That's page 22, my lords. Lords, here, my lords, the respondent was engaged as a daily.
That's again, this is the first date. So the same order is that. Notice returnable, same order. Where is that?
10th October.
10th October.
Supplementary list for orders item.
Same orders in 53. Yeah?
Item 57.
My lord, 57, I have, as per the last order, I have already filed the consolidated cost title, my lord.
All right.
Let it come for fresh admission, my lord.
Why? It's already a 2014 matter, sir. Tell us.
My lord. My lord, here, my lord, the challenge is made to the order of the Honorable Single Judge, where the Honorable Single Judge has stayed the execution without, my lord, giving opportunity to the appellant, as well as without, in violation of the statutory provision, which required 75% of the award amount is to be deposited, my lord, under the SMSC Act, my lord.
No, the challenge is to a 2004 order.
My lord, 2014 order, my lord. And my lord, the execution case is pending in Hyderabad, my lord.
Who's for the other side?
My lord, notice has not gone, my lord. I'll take notice by speed post, my lord.
No. What has happened to ARBP 122 of 2013?
My lord, till it is pending, my lord, before the learned district judge Cuttack, my lord.
Why? What's that petition under 34? Section 34?
My lord. And my lord, as required, 75%, it has not been deposited, my lord. They straightway come to the before the honorable in writ application and obtain the stay order.
Oh, nice. Notice
without giving any notice, my lord.
All right. Notice returnable 27 September.
Obliged, my lord. By speed post, my lord.
Yeah, by speed post. Tracking report prepared.
Supplementary list item 58.
Obliged.
58. May please, your lordship.
Well, before my Advocate General, my lord, to proceed, yesterday I have received a further affidavit they have filed. Yesterday evening they have filed, my lord, flag G. I have to file a short reply because in the meantime, my lord, I have commented to lordship judgment.
Mostly there are different circulars and rules. So if my learned friend has a problem, my lord, can it be next Wednesday?
All right. Which is the new affidavit filed?
That was, my lord, at flag. Flag G, my lord.
Where is that?
I made this statement. Pursuant to order dated 11/7, my lord.
The index runs not annexure 6 onwards.
You got it? Counsel for the respondents needs time to examine the further affidavit dated 22nd August 2022 filed by the appellants. At its request list on 14 September?
Well,
lordship, please.
14 September. All right.
Item 59. May I please, your lordship. It's the second round of litigation, my lord. May I draw my lord's notice to page 129.
Again, delay is condoned.
I think, Lord, there is a delay.
Yeah, delay is condoned because of COVID. Just the same explanation.
Lordship may kindly recollect, this is the same matter, my lord. Well, in the first round of it appeal, there was a long delay for which a lordship has imposed 25,000 rupees cost, my lord. So, my lord, this is happening.
Because of
and there, my lord, now this is with regard to the State Orissa Mining Corporation, my lord, the implementation of the pension rules, my lord.
Correct.
Yes. And the lordship had heard it extensively, my lord.
Right.
And then had restored the matter to the file of the Honorable Single Judge.
Correct.
Then the Honorable Single Judge, my lord, had held that yes, it is the action taken by the state is illegal and wrong. Against that, the state has preferred an appeal, though state is not aggrieved. Because there is not a single pie going from the state exchequer, my lord. But still then they have filed the appeal. Not aggrieved at all.
What about the corporation? It has not filed.
Well, the corporation has not.
Has not filed.
No, then also they had not filed.
Right.
And this time also there is no appeal by the corporation.
the government corporation.
Doesn't matter, my lord. 617, my lord.
It's still
Companies
an independent entity. Yeah, it is still an independent entity.
It's a private limited company, my lord, because the number of shareholders are less than 7. Under Section 12 of the 1956 Act, my lord, though it is a 617 company,
but
it's not. It's
three
private.
appeals have been filed by the corporation also. 3 right appeals have been filed.
That I am not aware. In fact, copies have not been served. And corporation was supporting the case squarely, my lord, that whatever stand has been taken by the decision taken by the corporation has to be, my lord, strictly complied with. My lord, what has been held, my lord, at a my lord, action at law, my lord, it's not like a game of chess. You take one particular stand at a given point of time, then take a prevaricating stand.
Yes, sir. May I bring my lord's notice, page 139?
Let all the cases come together, my lord, if at all any other appeal is filed.
No, I won't let us just hear him. Yes.
Okay.
May I bring my lord's notice, paragraph 27 of page 139. Earlier, your lordship had decided the issue, and relevant paragraph 27, it starts from page paragraph 27.
Yes.
The above submissions have been considered. Indeed, the ratio of judgment of learned single judge turns on a single ground, that is violation of Article 14 of the Constitution. This is premised on employees of OMC being treated on par with those of two other PSUs, OHPC and OPGC, in the matter of pensionary benefits. The learned single judge did not examine any other ground, as has been argued by the contesting respondents. In other words, the intrinsic merit of the proposal of the management of OMC made way back in 1991 for introduction of pension scheme was not examined by the learned single while issuing a mandamus to the appellant to reconsider the introduction of a pension scheme for the retired employees of OMC. Then a lawsuit turned to paragraph 30. Therefore, the court is not satisfied that the contesting respondents have made out a case for the applicability of Article 14 of the Constitution vis-a-vis the pensionary benefits enjoyed by the employees of OHPC. Consequently, the court is unable to agree with the conclusion of the learned single judge in the impugned order that direction date 28th April 2000 of the application rejecting the proposal for introduction of pension scheme was violated by Article 14 of the Constitution of India. Therefore, required to be set aside on that ground. So, your lordship, in para 32, consequently, while setting aside the impugned judgment of the learned single dated 29 January 2019 for the aforementioned regime, this court restores the writ petition to the file of learned single judge for a fresh consideration on the grounds other than the ground already examined by the learned single judge. It is clarified that this court has expressed no opinion so-and-so on so-and-so. Then, the writ petition shall now be listed before the learned single judge on 1st August 2021 for direction. The appellant shall file not later than 2 weeks prior to that affidavit and the documents which according to it are relevant for the issue arising for consideration in the said writ petition. Your lordship are directed to file an affidavit before 2 weeks of 1st August 2021. Then your lordship may turn to page 143.
Yes.
This is the affidavit. Appellant filed it on 14/7/2021. This was rejected, your lordship may see. This was filed in compliance to my lord's direction. Our affidavit was not taken into account Your Lordship may see page 241.
Yes.
By order dated 8/12/2021.
Yes.
And again, my lord, the impugn order starts at page 243, but your Lordship has already decided at paragraph 26, 27, 28, and 29, reiterating all those facts. Again, on the violation of Article 14, this Honorable Single Judge has allowed the repeats. And all the documents we have annexed in our affidavit, which are vital points for adjudication, that has been rejected, though it has been filed in accordance with my Lord's direction. The operative person might draw my Lord's notice, page 319, paragraph 45. May I read, my lord?
Yes.
In view of the law laid down by the Apex Court and by applying the same to the present context, since similarly situated PSUs such as OPGC and OHPC, having come within the gold category, have extended pensionary benefits to their employees, non-extension of such benefit to the similarly situated PSU like OMC Limited, even though as a matter of principle, the state government has approved the same, which has received the concurrence of the final, amounts to violation of Article 14 of the Constitution of India. As the equality, the basic feature of the
Actually, the reconsideration was to be grounds other than Article 14.
Yes.
But so clearly stated in the remand order that the single judge should consider grounds other than Article 14.
But that has been considered but not being placed, Malad. Malad, this is something in extra to what the Honorable Single Judge has decided.
There's the question of going back to Article 14 at all.
Malad, that is Malad, an issue, of course, I will address later on. Lordship, may kindly come to page 299.
Anyway, we'll hear this at length.
Yes, Lordship.
You say notice, Mr. Accepts notice on behalf of respondent 1, is it?
Yes, the Federation, Malad.
So who's appearing for respondent 2?
Mr. Muduli, PK Muduli.
He's not here.
I'll serve him copy.
All right. Mr. Muduli accepts notice on behalf of respondent 2. Till the next date of hearing, there shall be a stay of the impugned judgment of the learned single judge. List on 6th December.
Well, I'll just take one minute of Lordship's time.
Yes.
If Lordship permits, Malad.
Yes, please.
The Lordship may kindly recollect after the judgment was delivered by this Honorable Division Bench, Malad.
Yes.
Then we had filed a review application for Lordship, Malad.
Correct.
Stating specifically that other than Article 14, the Honorable Single Judge has also traversed to other points which has been dealt with. And the review application was not entertained on the ground that if that has been dealt with by the Honorable Single Judge, then there will be no difficulty, in fact, again to further deal with the same aspect, Malad. That has been exactly dealt with in page 299, Malad. Okay. Everything has been discussed in details.
All right. All right.
Let's stay up that impugned because
just stated.
Supplementary list item number 60.
Malad, 6th of December.
Item 60.
Malad, may I pray all the writ appeals, Malad, which have been otherwise on that day, time will be taken on that ground. all the writ appeals which have been filed against the judgment of the Honorable Single Judge may come together, my lord.
Have you filed other appeals?
Give them a numbers.
I'll give the numbers. In course of the day, I will give the numbers.
Then all those writ appeals will be taken on board and notice same thing.
Yes.
All right.
Item 60, Lordship, on behalf of Mr. Debasnan Das, our name may kindly be deleted as because a prisoner petition has been received in the case, my lords.
Sorry, what have we received?
But Lordship, our name of Mr. Debasnan Das and associates may kindly be deleted from the cause list, Lordship.
Who's appearing for the appellant? No, why do you want deletion?
A prisoner petition has been received, Lordship, in the case.
Where is that?
Hasn't been flag marked, but on the last occasion.
There is no representation.
No, it's just a representation. It's not a present petition or something.
On the last occasion, as per my instruction, Lordship, office of Mr. Anirudh Das has appeared.
Who's Kedar Chandra Sarangi?
Kedar Chandra.
They are submitting on the last
Yes,
occasion.
Lordship, consent has been given to us, Lordship.
Sorry?
Consent has been given to us, Lordship.
So are you ready with the matter?
Yes, Lordship, but today I pray for time, Lordship.
Why?
Mr. Das has some personal difficulties. Mr. Das will conduct this case, Lordship.
Criminal appeals, no one is prepared to argue. Why is that? The man is sitting in jail, and why are you not prepared to argue the case?
In this case, paperwork is also not ready.
Oh. Okay, the name of Debasnan Das and associates be deleted. Mr. K.C. Sarangi's advocate be shown in his place. Paper books be readied and be supplied to learned counsel to the parties within 4 weeks. List on 7 December.
Supplementary list item number 61.
My lords, item 61, I am appearing for appellants through VC. Your lordship, I am challenging the impugned judgment of Honorable Single Judge. No notice was served on us. No opportunity of hearing was given to us. There is a direction under Annexure 1, the impugned judgment, to give promotion to the respondent number 1 from the date of retrospective date, that is from 6/4/2016, when he was in jail custody. The respondent number 1 was arrested in a vigilance case in giving fictitious loans from the bank, and he was in jail from the date when the order was given to give him promotion to the post of SGM and then to the post of Deputy General Manager. That we are challenging, my lords. And your lordship, see Annexure 5 at page 28. Annexure 5, page 28. The respondent number 1 has written to the managing director that I was on judicial custody from 21st December 2015 to 17th May 2016 and was released on bail on 18th May 2016. And so how can we give in promotion from a retrospective date, that is on the date 6/4/2016, when the respondent number 3 was promoted? It cannot be implemented, my lords. And moreover, my lords, he has filed several writ petitions previously. He has not disclosed before the Honorable Single Judge. Annexure 2 and 3, as per the direction of the earlier writ petitions, his representation was disposed of, and he did not challenge the same. Annexure 2 and 3, my lords, is there. And
1 minute. Short point is that you were not heard by the learned single judge, correct?
Yes, my lords. No notice was given to us.
Yes, what do you say? It's that a very short point. Who's appearing for the other side?
May I please your lordship?
Yes.
My lord, actually my senior, Mr. Suryanarayan Patnaik, was appearing for this case. My lord, recently he has been appointed in the government side, my lord. Actually, today I do not have the file with me. So I was supposed to argue the case, but today, because of his elevation to the government side, I could not get the file. My lord may grant me a very small opportunity and a very short adjournment in order to come prepared with the case.
Counsel for the respondent states that he's not ready with the matter today. Is there an
I'm
interim order
sorry.
here?
Yes, the interim order is there on 9th February 2022.
All right. Interim order to continue.
Obliged matters.
List on 13th December.
Much grateful.
Supplementary list item 62.
Please, your lordship. My lord, in the
Is
meantime,
this is filed as a PIL, is it?
yes, my lord. My lord, in the meantime, some serious developments have taken place.
Some 4 applications have been filed.
My lord, I have filed an affidavit dated 16/8/2022. Now, I was just recapitulate the facts, my lord. Your lordship had held that the impugned rules are inconsistent with the RERA Act, and thereafter the state government had asked time to have a meeting with the RERA to sort it out if it can be reconciled. Ultimately, the meeting took place. They found that it could not be reconciled. And then a statement was given that a fresh apartment ownership bill, they are ready with it and they will be bringing it, my lord. This has happened till today. Now, your lordship, the IGR issued a public notice, which I have filed at Annexure 2, page 10, my lord.
Which is this affidavit you're referring to?
16/8/2022, my lord. In this WPC 18799.
Where is that? Just take. Yes.
My lord, page 10, my lord. I'll read it, my lord.
Yes.
Yes. This is for the information of registrant public that pursuant to the orders of the Honorable High Court of Orissa and so on. So the registration of apartment has been put on hold because of non-compliance of provisions of RERA Act and rules which violate 22A of the Registration Act. RERA came into force in the year 2017. Hence, any apartment completed before commencement of the RERA Act don't fall into this category where restriction can be imposed. This is one part. I'll come to it later. Secondly, apart from that, if any apartment has formed the association of allottees as per section 11(4)(f) and section 17 of the RERA Act and has complied with the RERA Act, then there is no restriction for transfer of apartment by the developer. Exactly, this is why the PIL has been filed, that we are not able to form the association. Now, there was a trick nexus between BDA and this IGR. BDA has started registration of apartments under this impugned rules, which has already been held to be contrary by your lordship. State has admitted it is contrary to RERA Act. We will bring up fresh rules. BDA has started and has given registration to apartment consisting of owners. Now, it's a complete mess they have created out of themselves. My lord, at last page 17, I have filed one document of BDA. The declaration in Form B submitted by sole. I have given to everyone the copies. The LIC HFL Home Care Bhubaneswar, as per section 13 of the Odisha Apartment Act, as is governed by and satisfies the provision of this act, subject to the outcome of WPC number so and so. The declaration submitted by the developer is hereby endorsed for registration under Registration Act.
Isn't BDA a party here? They're not a party.
My lord, in the connected writ, they are a party.
Who's appearing for BDA?
Let me just show, my lord.
Any copy of this petition, so whatever I'm hearing only.
I have given copies. I have all the proofs, my lord. Every time they say that they have not received the copies.
So yesterday I had asked for a copy of the affidavit from Mr. Agrawal.
My lord, I have the signed copy of the BDA. It is really a false statement that is being made. I have his signature. Last time also same issue. When I started to argue, the files came out from everyone's brief.
No, I did not understand. Last minutes, I have not appeared. I don't know because you were telling about the case.
My lord, I am arguing now against BDA, my lord, first. I'll just show in that connected writ petition, my lord, this 38186. Only one document I'll show. My lord may take up this 38186 at flag B, IA number 11525. Page 5.
On IA, I received minutes on 23/8/2022, means yesterday minutes.
My lord, at page 5 and page 6. Your lordship may see at page 6. Certificate of Registration of Apartment Owners Association under Odisha Apartment Ownership Act and the Amendment Act. They have tried to overreach your lordship's order. The state government has itself said that this act is irreconcilable with the RERA Act. They are going to bring a new act, and this has been issued on 22nd August. When this matter is pending, their advocates are appearing. The builders are going there and registering it. Look, This is completely overreaching and contemptuous on the face of your lordship.
What minors, my learned friend submits minors, I am not aware of receiving a petition yesterday on 23/8/2022, that is for petition for intervention filed by one Swati Nayak.
Yes, that is the one.
Come to page 6 of that application.
Yes, that is the one I'm referring.
That is, I received it yesterday evening only.
No problem, sir. I am reading it just 2 minutes before you read.
Yes.
Just now, when he read it only, I read this. I'm able to understand what the certificate says. Are you having a difficulty, sir?
No. That part I'm not disputing.
So let us answer that. Then you please answer, how is this kind of a certificate issued?
That means I have to take instruction.
We'll immediately stay the certificate, sir. Please let anybody not be under the misapprehension that they can overreach the court. I don't mind issuing notice of contempt to this competent authority. Who is this competent authority?
Competent authority.
The secretary of the BD.
I'll straight away issue notice. We'll straight away issue notice to this competent authority.
I mean, permitted to take instruction.
You can take any number of instructions. We are right now staying this because even as we speak, I'm sure he's busily issuing these certificates.
Yes, I'm not standing in the way, but minors pass appropriate order. But fact remains, I received it. I'm to take instruction.
You say IA number 11525 of 2022 in writ petition 38186 of 2021. Notice Mr. Dayanand Mahapatra, Learned Counsel for the Bhubaneswar Development Authority (BDA) accepts notice. A specific order is issued staying the operation of the registration certificate issued on 22nd August 2022. Which is annexure 1 minutes to the Mr. Annexure 1.
Annexure 1 of this.
Which is at annexure 1 to the application. Notice will also be issued to the Z1 Apartment Owners Association.
No, my lord.
Kalaranga, Bhubaneswar district.
It's not being served on us.
They are opposite, but I'll come to them. They have also filed a similar petition before the BDA. You form that association. I have also annexed it.
They say the single court's competent authority, BDA, who the court is informed is the secretary
of the BDA,
will remain present on the next date of hearing to explain how the said certificate is issued despite the orders passed by this court on
12/5/2022 and
12/5/22
and 22/6/2022
and 22/6/2022. Further, the BDA is specifically restrained from issuing any similar certificates hereafter till further orders of the court.
In the same writ petition, another affidavit 16/8 in the same writ petition, another affidavit 16/8/2022 only. In the same writ petition, another affidavit 16/8/2022. Annexure 1, page 4. This is Trident Properties Private Limited. We are glad to inform that the meeting of Trident Galaxy Apartment Owners Association has held on 3rd August 2022 and following office bearers have been elected, for which my learned senior is appearing.
Yes.
It is issued on 15th August 2022. So everyone is going around and forming associations when the law is and state government has accepted the law is inconsistent with RERA. Yes, they have no respect at all for the court orders.
May I submit one thing? The IA which he has filed, if I'm not sure, but I don't have a copy of that IA.
That can be served on everyone.
No, my lord, what I understand, my lord, if I'm a party appearing in this case, if he has filed something, then he should serve. Before it's taken up, at least he should have the courtesy to give it to the counsels appearing.
Serve this copy for whose client Mr. My learned senior is appearing. I have served. I have served upon you, sir.
This affidavit he has served.
Sir, I have the signature of your Trident property. Your junior has received it on 16/8.
Not the IA. That IA he has.
Sir, IA, you are not concerned with the IA.
Exactly. So he is giving part documents.
No.
That IA, what it contains, am I not supposed to know, my lord?
No. The IA is not concerned with Trident, but if you want insist on this,
I'll give it.
I will serve a copy on you.
The second matter, my lord, is not a PIL, it's inter parties. Second matter is vis-a-vis Trident only. Now, suppose he files an IA,
you say notice,
in all fairness,
that notice you say copy of this application be served on counsel for the parties.
Yes,
I have moved an application, my lord, at flag E, if your lord should see. I am for the credile. My lord, what I am trying to mentioned, my lords, that it is an innocent order, my lords, I am seeking. It will take care of the interest of all the stakeholders.
No, which is this application in which matter?
Flag E, my lords, your lords should see IA number 11469.
In which writ petition, sir?
In the first case, my lord. In the first case. I'll point out, my lords, 2-3 pages of this application. Which would be, lords.
You are by Confederation of Real Estate Developers Association.
Yes, my lords. Yes. Can I
you want a vacation of the stay?
No, I'm seeking a variation of that order, my lords, because pursuant to that order, my lords, the registration has come to a standstill.
Sir, I have given lots of ways to for your representations, everything to be considered by the state government. No. It's for the state government to respond now.
No, what had happened is,
I don't know what they're doing.
No, what had happened
now? Actually, Mr. Parija is here. He can tell us what is exactly happening.
There is one instruction which we have received that the new act is now.
Just the mic.
I'm so sorry.
No,
my lord, that new act is underway, my lords. It's now pending before the law department and very soon it will come into effect.
Okay.
My lord, what was disturbing your lordship, as if I have understood it correctly,
yes,
that section 17 says you can't register.
Correct.
Unless you set apart whatever is required for the common area.
Correct.
And
correct.
that should be with the association.
Correct.
So therefore, my lord, because there were no associations, the registering authority says I am not going to register anything. So the question is, what my learned friends are saying, that nobody has come before your lordships, at least with a draft agreement which will be compliant to 17.
But precisely, I'm saying that, lords. I have come.
Then there is nothing on record. You are only saying.
No, application. I'll place it, my lords. Your lordship kindly see 3 pages, my lords, of my application.
What your lordships were of the view that let this registration be delayed by a couple of months instead of having litigation for 5 next year.
Exactly.
So therefore,
actually, the very people whom they're all standing up for will be in deep trouble.
Yes,
I think you're not realizing that.
What happened?
Let me just finish.
Yes.
Just give me 2 minutes. I'm saying something in your favor.
Yeah, I'm so sorry.
So why don't you get a draft agreement which will be compliant of section 17?
I have said so in that order. In fact,
that is precisely I'm trying to do, my lords. That precisely I'm trying to do. Your lords, you kindly see 3 pages of my application, my lords. I can place it, my lord. My lord, in the Supreme Court, my lord, that Ashwini Upadhyaya matter is going on. In Ashwini Upadhyaya matter, the Supreme Court has said that you should have a sample agreement to sell, and which will be pan-India, my lords. And the sample is approved by the Supreme Court, that is Chandigarh model, my lords. And the Chandigarh model, I have filed it. That is parametria same as we are following here. So therefore, what I'm trying to submit, my lords, that during the pendency of this petition, my lords, in the interregnum, at least let us follow, my lords, the Chandigarh model.
There being a law changed, how can we suddenly just adopt this? The law has to be, it has to be compliant with the law.
But that is the direction of the Supreme Court, my lords.
No. The Supreme Court is approving a model without discussing the individual state laws, please.
That's right.
In fact, you show me one paragraph, because we went through this entire exercise which you are saying.
Yes.
In the hearing of May, we went through all the orders of the Supreme Court. We found that it does not deal with the specific issue we are dealing with here. In fact, the order says so. I don't know whether you have had the benefit of reading our orders.
Yes, I have read.
We've already discussed the Supreme Court case. What's the scope of that petition?
In fact, there are 2
we pointed out what is the problem here. The problem is the 2 laws are not consistent with each other.
That's right.
Till you remove that inconsistency, we can't simply keep our order registrations.
So I have 3 suggestions, my lordship, your lordship, in the interregnum, my lords, if everything has come to a standstill today. My lord, there is a loss to...
Not just, it is, you are making it seem as if overnight it came to a standstill. Do you know the number of orders passed and since how long?
Yes, my lords, I have gone through.
I've been giving them a long period of, to rectify. None of them saw the issue at all.
But what has happened today?
None of them. In fact, it's taken some time to even convince the state government there is a problem.
Right.
So it is not as if suddenly overnight things came to a standstill. You brought this upon yourselves. Let's be very clear. You brought this upon yourselves.
Yes.
By refusing to see what the problem is.
We recognize the problem.
Sir, by doing this, you're creating more and more problems for the persons. They are all innocent people. Their hard-earned money they have given to all of you for flats. And you're now presenting them with these kind of half-baked solutions which are going to land them in further trouble.
Standing in the way, my lords.
These are not solutions to the main problem, which is the law.
What I'm trying to submit,
I'm trying to be pragmatic to get over today and tomorrow. And to somehow,
I think I'm misunderstood, lords. Kindly appreciate one thing. Not an inch of
unless the law is properly rectified, which we've discussed elaborately in the earlier orders, any stopgap ad hoc solution will create more problems than
It
it
has a
solves.
potential of creating litigation, my lord, that I appreciate that.
And not you will step out. You're all builders. You will step back, and the poor person who's purchased the apartment will be left to face the music.
I'm making a statement, my lords, not an
He will
inch
be
of
left
land,
to face the music.
not an inch of land, my lords, we are retaining. Either we are giving to the individual or the association, my lords.
That individual whom you are giving, the problem is this: the individual whom you are giving, if he does not have proper title to what he's getting, if there's some law which prohibits him from getting that title, he'll be in deep trouble. You will step baback and say, I don't have anything to do with it hereafter. It has left my responsibility. This is what you want to do. You want to wash off your hands.
No, my lords, as per the standard procedure, my lords, we have been doing.
So please help people who spend their hard-earned money. Please help them get a valid title to whatever they're getting.
Genuinely, my lords, we want to help. My lords, genuinely, I want. My lords, there are three stakeholders, my lords, primarily. My lords, the stakeholder is the home buyers, my lords. First stakeholder. Second is the developers, my lord. Third is the state government. And all three of us, my lords, are suffering today because of the everything has come to a
I don't mind suffering.
They cannot. So who's responsible for that? You just ask you yourself sit down and reflect who's responsible for it.
Perhaps the state, my lord. Perhaps the state. Because
you can say perhaps this, perhaps that. So there is a solution to be found. We've indicated in great detail. We've gone into the earlier orders how the solution can be found. The idea of those orders was to make them find that solution.
It is the only state can do that.
Advocate General says the solution is already there. He's asking you to just wait.
Yes.
Yes, my lord. Couple of minutes. I'll just submit, my lords. My lords, I know, my lords, I'm coming from a place where I represent some of the builders and some of the allottees. Now, post-pandemic, all these buildings have come up. Now they are on the verge of delivery. People are really impatient to get their flats. So as we speak today, my lords, the only law is this Apartment Ownership Act, under which an association can be formed. My lord may take it from me.
This is not the only law. I'm sorry.
My lord.
I don't know. I'm very surprised that you're here saying this. This is not the only law.
The other law which the state is proposing is yet to come.
No. The RERA Act. How can you say that's not a law?
My lord, as per the RERA Act, as per the PIL petitioner, for us to have these sale deeds in place, there has to be an ownership association. Otherwise, we can't transfer the title.
You're going back to all that we've discussed in the earlier hearings.
So unless the association, my lord, is formed, we cannot transfer title.
Correct.
So there is no law as we speak today for formation of associations except this law.
No, that law is being redone, please.
One thing, my lord.
As it fell from your lordship.
Come out with the time-bound, my lords.
We've already done all that, please. You're not just reading our earlier orders. This is the whole problem.
3 months.
So as we speak, there is the only law available is this. Now, these buyers, I have also filed interventions. These buyers are all impatient. They have paid 90% of their dues. They want to take their flats. Now,
so you please display your impatience with the state government. All right. You use all your good offices to persuade them to.
We are as
tomorrow morning, day after morning, tomorrow night, whenever.
My lord, lordships have my instructions.
We will not come in the way. Suppose the state government wants to bring it into force at 8 p.m. today. We will not stand in the way.
We don't.
If they say no, sir, 6 a.m. tomorrow is a good time. No problem.
That's what we are requesting. At least they should indicate.
We can't constrain the government, my lords. We are in fact praying for the same thing. We will be compliant. It's not that we have anything against our own.
May I make a small submission? Lordship may call it after 4 weeks. By that time, hopefully everything will fall in place.
No, I have no issues at all.
Yes.
We are only
Lord,
keen that there's a solution found.
If your lordship sees me, Lord, there was a high level.
We have
I've
given the
the
instruction
of the government which has come.
Where is that? Yes.
Good copy. We have given 2 copies, minutes.
Right. No, the other one.
Your lordship may see page 2, last but 1 paragraph, lords. And
but this is wholly silent on that Apartment Owners Act.
If your lordship sees, my lord, the next page, minutes.
Anyway, I'm only hoping that whenever you finally come to this solution, you're not silent on that Apartment Owners Act.
No.
I find no mention of it at all here.
If your lordship sees the enclosure, the minutes of the meeting.
Yes.
The modalities of execution, the convention, apartment owners association, so and so, in consultation with various stakeholders. I keep in mind, we'll also provide for formation of the association.
Okay, there is a proposed Odisha Apartment Ownership and Management Bill.
Yes.
So that should take care of it.
Lordship pleases.
All right.
Yes, that has been circulated for public opinion, and I should feel they should bring it. Fine. As soon as they can bring it, problem will be solved.
My lord, may kindly allow me for a moment. So till that comes in, now we are in a vacuum. All these people are now we are not able to deliver possession. Now, Mr. Mohit Agarwal, he appears for the Residents Welfare Association. Now, he should think about the plight of, right from the beginning, I have been saying that industry is willing to comply with the law, whichever the state will bring. But till then, if you block us from delivering apartments, we are now in a soup. Now, as it fell from your lordship that we will convince the state, why will the state hear us? We are also trying to attain to customers post-COVID. This completion has happened post these 2 years of huge problems. So now all these flats are ready. They have paid 90% of the dues, but we can't deliver.
No.
Only way, my lord, may hear me for a moment. The only way for us to deliver flats is to get it registered, which was stayed today, my lords, without that IA being served on us. Only through that route only we can deliver. Otherwise, we can't.
You should not, Mr. Mishra, I don't understand what you're trying to say.
My lords.
There is a law which is inconsistent with the RERA Act, which said so in our orders, despite which registration is happening.
Registration.
Under what law is registration happening?
My lords, that registration would be in sync with the RERA Act.
It is not, please.
Because we would be giving the common areas.
You see the certificate. It is mentioning both.
My lords, so far as
the certificate is wrong, please.
No, my lords may see that order.
In your desperation, I'm sorry to say this, Mr. Mishra, not you meaning, I'm saying the police persons you're standing for, in their desperation, they're doing something which is not permissible in law.
My lords may kindly let us revisit that issue. This act has not been stayed. Some of the portions which don't give the common areas to the owners, that has been stayed. Now, my lords may kindly see. If this is allowed, then only we can transfer to the owners. Otherwise, this again goes into a huge log jam.
There's no log jam. Once the new law comes, there'll be no log jam at all.
Absolutely.
So the whole idea of having a new law is to remove the log jam.
So now, my lord, all that I understand without that IA being given to me is that he's agreed that the common areas are not being given to the Residents Welfare Association.
Correct.
Now, what we are trying to do is follow the law as on today and give it to the association. We
cannot follow. That's not capable of being followed. I think we've gone through this entire thing. There are 2 orders explaining to you why it's not capable of being followed.
Once the common
areas, purposes, please.
Once the common areas are given to the owners association, it doesn't violate even my lord's order.
May I submit my lord's a few lines? What my lord says, I understood my lord's sentiment, but fact means, in fact, what I've gone after going through these petitioners that certificate issued, I must I bow down, my lords. We will withdraw all this.
Yes.
We'll stop all this.
Please. Just wait till he brings a new law. See, we have to look at the interest. Ultimately, what's all this for? The interest of the buyer.
Kindly record my undertaking, my lords, and kindly, my lords, drop that. So far as that order is concerned, kindly modify that order. And we'll instruct our officers and the designated competent authority.
That order remains. Mr. Mapaga, that order will remain. Let him give an explanation.
I just want to join the dots. The IGR issuing one public notice, the BDA registering it, the builder, the larger picture has to be seen how they are acting in synchronization with each other.
No. These are all inferences from where he's drawing, my lords. We want to be compliant. My lords, may I just draw my lord's attention?
Stop all registrations.
So now all registrations are stopped. So many buyers now.
I'm sorry to say, this is something you brought upon yourselves.
Yes.
No, my lords.
This should have happened long ago.
6 years ago.
In fact, this court waited for months on end before passing those orders. You are aware of it.
I am.
So you brought it upon yourselves without actually acting earlier. So now I don't know who is to blame, but
the builders, my lords,
the court is not going to perpetuate an illegality. Certainly not.
My lords,
they have enjoyed it for 6 years. RERA Act came in 2016.
Anyway,
my lord, may kindly see that order. the portions of the sale deed which don't give ownership to the common areas to the owners, that has been found fault with.
Which is why I don't know if you've got the copy of the instructions that the AG handed over.
In fact, had he given me the IA, I would have been better prepared.
Not concerned. This is instructions of the government.
Practice, my lord. First, let's sort this out. I am a party in this case. He files an IA. He doesn't give me a copy. And he's adamant now that I need not, since it doesn't concern me, he will not give me a copy.
Please. We have already passed an order to give you a copy.
No, he should have given it beforehand, my lord.
Paragraph 4 of your lordship's order, the 22/6/2022, my lords. If I can only bring that paragraph 4 into your lordship's notice, I'm appealing for High Odisha, my lord.
Yes.
There was an issue raised on the last occasion with respect to registration of these agreement of sales.
Yes.
Your lordship had directed us that representation is to be made to the state, which will be considered by the state within a period of 15 days, my lord.
Correct.
But subsequent thereof, we have made representations, but they're lying with the state authorities.
No. So what has happened, Mr. Mishra, is we've got instructions from the government, which has been received by the Advocate General, which says, in fact, quotes that para 4 of that order, and then says they've had a meeting and they're coming up with this new amended bill, and they're going to ensure that the draft agreements are in sync with the law.
But the draft agreements are already appended to the rules, my lord. That's my humble submission.
Those have to be amended. So those draft agreement formats, which are with the rules, are not consistent with the law. So those have to be changed. In fact, that has been pointed out in the order, please.
Your lordship, on the last occasion,
Learned Advocate General.
My lord, your lordship, on the last occasion, had directed in paragraph 5 of the order that the court will also like to impress upon the ORERA that it should forthwith re-examine the formats agreements specified in the rules and bring them in conformity with the requirements of the RERA Act. The rules thereafter, my lord. We have already done that part of the order, my lord. We have complied. We have given our formats, my lord, to the state government.
All right. That they acknowledge in this note.
My lord, the cost of reputation, your lordship would consider, my lord, because 4 weeks time, and thereafter, my lord, it will take its own time, my lord, for bringing the new law.
We have always fixed a time. As far as the present petition is concerned, we've been fixing a time. It's been coming up on all those dates that we fixed.
Because a huge
and every date there is a substantive order being passed.
Because there is a huge financial implication. The banks are involved.
So we are not at all aware, sir. We are not aware of anything like that. All these orders have been passed without being aware of any of these problems.
Your lordship may consider,
these problems have come up.
Mr. Mishra, you have come only to today's hearing, correct? Have you appeared earlier in this case? I'm sorry if I'm sounding a bit impatient, but I'm bound to be when I hear somebody suddenly emerge in one hearing and then give us talks about financial difficulties, other difficulties, and all that. We've been facing this from day one of the hearing, which is why I'm saying you brought this upon yourselves. If you had acted earlier, you could have easily seen the problem. You could have easily persuaded the government to say, listen, we are in this deep trouble. Find a solution.
The state government is also a stakeholder, my lord. They should have expedited.
Everybody. See, that's what I'm saying. The fingers will point everywhere except yourself. That is a tendency. That's human tendency.
I only miss it.
My lord, Mr. Mishra is holding a brief for the day. And I'll tell you something, Son Lordship, something in very lighter vein. Justice Kehar was sitting in court 4, and there were a batch of education matters. He was always filing SLP, and he was dismissing. So he one day told him that if we again file, I'm going to hit you. So what he did on the next day, he engaged the then Attorney General, Mr. Rohtgi. So when Mr. Kehar saw, Justice Kehar saw Mr. Rohtgi, he said, you please go out, send that boy inside. No, notwithstanding so many.
Yes. So we'll just, you see, the Learned Advocate General has handed over a set of written instructions received by him from the Housing and Urban Development Department, Orissa Urban Housing Mission, dated 23rd August 2022, which interior states that the HNUD department has prepared the draft Odisha Real Estate Regulation Development Amendment Rules 2022 for effecting necessary modifications in the agreement for sale and making it compliant to the RE/R&D Act 2016 with in principle approval of the government in the HNUD department. Full stop. It is stated that after vetting of the law department, steps will be taken to notify the amended rules in the official gazette of Odisha by observing necessary procedural formalities. Paragraph. The learned Advocate General adds that he expects the above steps to be completed within 4 weeks from today. Paragraph. A concern has been expressed on behalf of associations of resident welfare association, residents, associations of residents, as well as association of builders, that the delay in finding a solution to the problem is causing serious difficulties as registrations have virtually come to a standstill. Paragraph. Without the legal issue being resolved, to permit registrations which take place on an ad hoc basis would cause serious problems for the very buyers for whose benefit these laws have been made. Full stop. Consequently, it is not possible without the law being brought in sync with the RERA Act. The law concerning registration of associations being brought in sync with the RERA Act for the court to simply permit registrations, as that would only add to the problems rather than resolve them. Full stop. It is expected that the government will complete the exercise within the period of 4 weeks as assured in the court today. Full stop. List on 27 September.
Lordship, please. My Lord, subject to your Lordship's indulgence, just one word regarding the owners who have applied for the flats and paid the amounts, because their entire loan, everything is dependent on
Correct.
the
I've just
earlier
added that
agreements.
paragraph. See, the problem is if you try and find an ad hoc temporary solution.
The agreements, because if that is declared like it is against the law,
wants for that.
Bank may recall the loans and everything. So
no, look at the other side. Look at the other side. You have some ad hoc agreement.
No, my lord, I'm not saying that. The state government should also look into that aspect, that they're protected.
From 2017 to
because otherwise
they can't put a moratorium on loans and
no, because otherwise if it is recorded their rights, payment for the next paying the EMIs, my lord, they will come down to the streets itself.
Yes.
Look, all that I would submit, my lords, is that along now what Mr. Agarwal represents is associations. Now, associations, of course, they want a pie in this entire thing. That's why they have all come up, which is fair enough. We, in fact, right from 2-3 hearings, I have been there right from the beginning. We have said that we will be compliant. Whatever the government comes up, we will be compliant. Now, initially, a grievance was raised that these common areas are not being given. So now, when we try to follow the law which is there, then there is now this IA has been given to me now. It's against a party who is not in the writ petition. They are not parties. No prayer. That writ petition, if my lords would see, my lord may just take up 3.
No, but what is the purpose, Mr. Mishra? I don't understand. What are we trying to say now?
My lord, the writ petition where this order has been passed, that is vis-a-vis one builder. That is not a PIL, my lord. If my lords may take up that writ petition.
We can't have, these are all connected matters, which is why this list is becoming long also.
My lord, where
we can't have inconsistent orders, it's been tagged with this writ petition.
No, they have a right to be heard, my lords.
Of course. Who's saying no?
So without serving copies. And now, my lord, may kindly see.
We have issued notice only. Do not alert this IA, please.
The IA
and I've issued notice to that party also.
Yeah.
That association.
How my learned seniors pleading for them? I don't know.
No. My lords, I am to assist the court, my lords. My lord,
I've only issued notice.
My lords, I just want to draw your lordship's attention that the third writ or the second writ, that is not a PIL.
Of course it is not. So, but we have to, you see what happens if the lead matter is a PIL,
my lord,
which deals with those very issues in that other petition.
My lord.
That goes to some other court. You're going to have inconsistent orders.
No. This is in this writ only. This IA has been filed in a case which pertains to some other apartment.
Obviously. But that has been tagged with this main writ petition.
Now, my lord, may kindly...
The same issue is involved in both, please.
My lord, this IA, had it been filed in the main writ petition, then CREDI, which is a party, could have responded to this. Now,
No, somebody will respond. The BDA is a party.
now
the other party is a party. They will respond to it. What's your problem?
So there is, first of all, my lord, I want to submit, my lord, there is no violation of the court's order, as he said. There is
I don't know whom you're arguing for, Mr. Mishra. Now, let's be very clear. Mr. Mahapatra, appearing for the BDA, himself is saying that I see the problem. I'm going to instruct the BDA. Now you're standing up and saying there's no violation.
No, there is no violation so far as not handing over.
Mr. Mishra, whom are you appearing for?
I
have said the BDA has acted in violation. This is only a prima facie view. We've asked them to an explanation. Are you appearing for the BDA?
No, man.
So let's stop it at that. Yes.
The Lord said disposing of the application. I'll give you Xerox copy.
All right. Call it the next.
Item number 63. Manners fixing it, manners.
The Lord said disposing.
27.
27th of September, your lord.
Item 63.
63, the copy of the writ appeal may be served on 63. All the connected matters are coming up at 28th November. It is similar to item 55.
Maybe I have given a copy. I'll photocopy and give it to him.
All right. Fine. That's intercept.
Yes,
no problem.
Page 13 is the impugned order.
63.
Copy has not been served.
Same order.
Item 63, where I have appeared for the respondent, but no copy has been served till today. And you also have posted all these matters to 28th November. 28th November.
Right.
All the single judge order, similar order also posted to 28th.
Right.
So let him serve the copy so that matter can be hard on that.
Right. Yes, same order. It's already there. Actually, notice is already issued here. You simply say adjourn to 28th November. 28th November?
Yes, please. Copy served already.
Item 64.
Please, Lord.
Yes, please.
Here, with regard to with regard to election of the State Bar Council, my lord, we have challenged the order passed by the Lord single judge directing to hold election within a period of 6 weeks, my lord. So we have challenged it because pursuant to last order, my lord, Bar Council on 22nd August, my lord, has approved the list of non-practicing advocate, and accordingly, last page, my lord, you are therefore informed that the list of non-practicing advocate received from Odisha State Bar Council is hereby approved with the condition to include the names of non-practicing advocates of Kamakhya and Baleshwar Bar Association by considering their grievance. You are hereby informed to modify and prepare the list of non-practicing advocates accordingly and complete the process of election by following different rules and guidelines of BCI. It is further informed to you that the preparation of list of non-practicing advocates will no way affect the schedule of election as contemplated under Chapter 4 and 5 of the Bar Council of India Uniform Rules 2016, read with other relevant rules of Bar Council of India and further read with Section 8A of the Advocates Act. Thereafter, my lord, we have issued on 23rd, my lord, we have issued the list to the Registrar General Odisha High Court as well as Registrar General Supreme Court, my lord, in view of Section 20.4 of the verification rules, my lord. Now I will draw your lordship's attention to the rules, my lord. Well, page 78. Page 78 is the brief. My lord, your lordship take up writ appeal number 110/2022, my lord. Connected writ appeal, my lord. The two appeals.
No, I don't understand. So only two bar associations, Kamakhya Nagar and Baleshwar, you're supposed to
Yes,
consider
they have given complaint.
All right.
They have, that has been approved, my lord. Now we have issued your lordship on to 20.4. I am arguing with the rate appeal number 110/2022, my lord.
110.
Connected one.
Oh, I see. All right. Who is appearing for the bar council? You're there. You're also aggrieved by that order, is it?
Yes.
Oh.
Well, page 78, my lord. 20.4. The list of non-practicing advocates and names of advocates whose application for issuance, verification of certificate of practice and dismissed under Rule 13 shall also be published by the State Bar Council as per law after list names are approved by the Bar Council of India. Now they have approved, my lord. List of such non-practicing advocates is to be furnished by concerned State Bar Council to register Supreme Court of India, register of all high courts, subordinate courts of the state, Bar Association of Supreme Court of India, and Bar Association of all the high courts and subordinate courts. We are at this stage, my lord. Now they have also instructed us to follow chapter 4 and chapter 5 of the 2016 rules, my lord. Now, your lordship, see, if we follow that rule, my lord, we require 220 days to complete the election, my lord. Now, your lordship, see, page 66. Chapter 4, my lord. Preliminary and final electoral rules, my lord. The list of non-practicing advocates shall be sent to the Bar Council to every bar association, and the notice sent to individual through post shall mention clearly about the amount under Rule 40 to be paid by the advocate, and the notice shall also mention that if the advocate doesn't pay,
you can't send it through email. Why should you not send it through email? Why should it be sent only through post? Why rule was framed long ago, correct? Why can't you send it by email? Because in email, in one evening, you can send it to all the bar associations through email. You just have to collect the email addresses. You can send it forth immediately, instantaneously. You can send it. If you want, we'll say that the word post will include email. It will save how many months for you? It will save several months.
No, next page is the date given by the next page 67. After 160 clear days of such publication of notice, the State Bar Councils are published.
So you publish it today, then your statement reduces by 160 days.
I heard that the list is 1,175 pages. That the list approved by the Bar Council of India is 1,175 pages, my lord. That has been sent to Bar Council, the Registered High Court, the Registered Supreme Court of India, and all the subordinate courts. It's that stage. Yesterday we have completed that, my lord.
No, if you scan it, that 1,175 pages, you just have to scan, send a soft copy with an email. Just scan it. No need to send it by post. Will save a lot of money also.
My lord, I am appearing for the respondents in this case. If your lordship permits me, can I say something? My lord, that so far as the verification rules is concerned, it is all right. Now they are harping on that after the verification rules is complete, my lord, it will be the 2016 rules, my lord, which will be controlling the conduct of the election, my lord. That 2016 rules, your lordship will kindly find that is in counter affidavit, page 69. 69, my lord.
If your lordship is holding 110, then it's 16.
Yeah, that's what. We're looking at those rules only.
Lord, your lordship will, and one line I am bringing you to. Lord, this is a mess, Lord. This election term of the Bar Council expired in 2009. This 2015 rules, verification rules came in 2014. And they didn't do anything till today. And after we have started file this after several extensions under 83, Lord. They have done it. My own, your lordship may kindly see the 2016 rules, my lord, at page 64, my lord, of the writ appeal, my lord. Has your lordship got it?
Yes.
These rules Has your lordship chapter 1, my lord.
Yes.
These rules shall be called as the Bar Council of India Uniform Rules and Guidelines for Election of Bar Council of 2016, my lord.
Yes.
Then they say date of commencement, my lord. Clause 3, section 3, rule 3, my lord. Has your lordship got it now?
Yes.
Thereafter, my lord, 2 extent, 3 is date of commencement.
Correct.
These rules shall come into force on the date of publication in the Gazette of India, my lord. My humble submission is that this has not been done. What has been done, your lordship will get at page 114 of the counter affidavit filed by the State Bar Council in the writ petition, my lord.
Let's in the read petition that the counter that is in.
In the read petition, that counter is there, my lord. May I ask your lordship? I know, my lord, it is very painstaking to kindly look into page 114 of the running page of the writ application. Maybe
Yes.
I am wrong in my submission, my lord, but I think I should bring it to your lordship's attention, my lord. My lord, has your lordship got it, my lord?
That's in the read application. In the read petition, they have filed a counter. In that counter, that page is referring, my lord and senior.
114, my lord.
And the that document is annexed to the State Bar Council's counter.
Read petition number 21100 of 2021.
Correct, correct.
Has your lordship got it, my lord?
We've got the counter affidavit. Yes.
State Bar Council.
Running page.
Running page, my lord.
Running page of that read petition 114, my lord.
No, the counter affidavit starts at page 161.
State Bar Council counter, my lord.
Yeah, first rate. This is 21100.
Well, counter file in.
No, that's the writ appeal. He's referring to the counter file of the writ petition.
Yes, my lord. I am referring to the counter file in writ petition. My lord, annexure R by 3.
C by 2, I think.
C by 2.
Yes, my lord.
That's the Gazette notification.
Yes, of 2020. That's the rule.
Correct.
That's the election rule, my lord.
That's there. Yes.
That is what they say. My lord, your lordship will kindly see that that subject heading is given. That is rules under section 615T2 read with section 410B and section 71GK read with section 48B, 49A, AB and 1 of the Advocates Act.
Right.
Then amendment to rule to 1 of the Bar Council rules.
Correct.
Addition of new rules, that is to the Bar Council of India rules.
Right.
Then, my lord, the General Council has considered to make necessary amendment in the Bar Council of India rules with regard to the matters relating to the election of the members of the Bar Council of India and office bearers of the State Council. Your lordship may skip it. Then part 2. Your lordship may carefully see. The Bar Council of India rules provide for the election of members of the Bar Council of India. The council has framed uniform guidelines in this regard in the year 2016, which are now to be treated as mandatory. Without making that rules gazetted, one line is that it will become mandatory. Does it give effect to the rules, my lord? That is one of my submissions. I may be incorrect, my lord. But that rule has to be given, come into effect from the date of the gazette notification. Now in 2016, they go on delaying the elections, telling that we have to follow that. In 2020, my lord, they come up with this notification where it says that it is mandatory. Lord, that has not seen the light of the day in any gazette.
But that itself says gazette something, what you were reading from earlier.
66.
No.
It does say Gazette only.
That required to be published in Gazette. 66 hours.
Yeah, but the whole that we are reading from a Gazette only.
No. 66, your Lordship may kindly see again. That is, begins with
64, my lord, 64, rule 3.
These rules shall come into force on the date of publication in the Gazette of India.
December 2020. 8 or 89. See, guideline is mandatory position, 89.
Yes, all right.
So this was never gazetted. Then in 2020, that gazette notification, they say that this route is mandatory. And they say that 2020, therefore this rule is already gazetted and it has the mandatory effect. That is their argument, my lord. Apart from that, my lord, we have quoted, my lord, 2 decisions of the Honorable Apex Court where plea was taken consistently that due to verification, delay in verification, it cannot be held. Now, my lord, your lordship will see April 2019, the term expired. Now we are in almost September 2022. Now they want 220 days plus 60 days. That is 280 days, another 8 months. But this is not an adversarial litigation.
No, Mr. Mohanty, which is why I'm suggesting that instead of posting it through snail mail, whatever we call it, surface mail, they can scan all these 1065 pages. Scanning will not even take 1 hour if you scan 1065 pages. And you can send it by email, which means you can send it in 1 day.
Yes.
If you are so minded, you can send it in 1 day.
If they are really interested, my lord, they can do it within 2 months, my lord. And earlier, my lord, your lordship will kindly...
No, the rule says 160 days. Otherwise, there's no problem.
Yes, my lord.
The rule says you have to wait for 160 days.
That's right, my lord. But your lordship may kindly look at page 126 of a schedule, which is submitted before the Honorable Single Judge, my lord. 126. So I am only telling that how they are neglecting to do this.
In the heat application, my lord, they have only prayed for conducting the election.
1 minute, Mr. Das, please.
Yes.
120, page 126. Has your lordship got it? No?
In the REIT appeal itself.
REIT appeal.
110, REIT appeal number 110, that page 126.
Has your lordship got it? No?
Yes, 126. Yes, list of dates of commencement of time frame for holding elections.
27, they say that election will be held on 4/1/2023. Now, but they want to have it in next September probably.
What has happened to this timetable? Let's talk, Mr. Das, let's talk of this timetable, which is there at page 126.
126.
Where are you on this? The declaration of non-practicing advocates is over now. But that's been delayed by the Bar Council of India by 6 months.
Yes, my lord.
So they've communicated this acceptance of your list, approval of non-practicing.
Yes.
This was supposed to be on 31st March. They've given it to you on 22nd August.
22nd August. That is the.
So everything has been pushed back by 5 months.
Yes, that is the reason, my lord.
Well, there is no requirement for approval under the rule.
Yes. No.
That's only an intimation.
No.
Anyway, now all the time is crossed and approval is already here.
20.4.
We can't put this back.
Yes, the 20.4 approval, what is there? Approved by the Bar Council of India.
No, man. That is gone.
20.4, first paragraph. But none of the provisions of the rule of 2015 or the 2016 has been challenged in the writ application. In the writ application, they have only prayed for conducting the election as per section 8A of the Advocates Act. And
what is your revised time schedule now? Give us that.
Now, my lord, today we have completed 20.4, my lord.
No, you give us a revised time schedule by keeping the word post as email.
Yes, my lord. I'll give as per, because we have already completed 20.4 stage, my lord. We have already intimated the list of circulation of non-practicing advocate to the Registrar High Court, Registrar Supreme Court, and all the District Bar Association, my lord.
You already communicated?
Yes. On 23rd, my lord, we have already completed.
Okay.
We received it on 22nd, and 23rd, my lord, we have sent it to all.
So what is the next step?
The next step is, my lord, 60 days is required for Rule 40, my lord, because that advocate welfare, my lord.
What is this default?
The list of, yes, my lord. Within a period of 60 days from the date of publication of notice, his name shall be removed. Suppose the advocate has not paid, that will be communicated, and that his name will be struck down from the list of advocates, my lord. So then only we can prepare the final publication of list, my lord.
May I just draw your lordship's attention to
what will happen, my lord?
Page 79, Rule 23. Lordship, can page 79, Rule 23. That same rule.
Yes,
which
yes.
my learned senior is.
Yes, yes.
Kindly have that proviso, my lord.
Yes.
Provided that elections of the State Bar Council is where a special committee or committees under Section 8A of the Act is or already functioning on the date of commencement of this rule shall continue under the existing rule as if the rule have not been enforced.
Just above, your lordship may read just above, my lord.
In such,
first paragraph, middle, my lord. 23, my lord, middle portion. No State Bar Council shall undertake to prepare electoral roll or to conduct election to the State Bar Council unless the process of verification of certificate of practice and of identification of non-practicing advocate is completed under these rules by publication of their names under Rule 20.4.
That has never been gazetted.
Already over. That is already, great respect to my Lord Senior, it has already been over. We have already communicated to the list, circulated to all the Bar Association of the state, as well as to the High Court and
But I
Supreme
hope
Court.
you gazetted these rules or you've not gazetted these rules.
the rule is not gazetted.
Because they'll come into force only the day you gazette it. You shouldn't turn around tomorrow and say, we never gazetted it, so it's not in force.
They themselves have annexed it to their encounter and there's not a gazetted copy. It's with a forwarding letter only.
So all these rules that you're quoting, these are all the 2015 rules, not 16 rules.
16 rules.
15 rules, my lord. Verification of rule is 15. The rule 16, my lord.
Is gazetted, my lord. Verification rule is gazetted.
No. When you come to that preparation of electoral roll, you suddenly are saying 2016 rules.
Yes.
Yes, my lord.
Mandatory guideline election of Bar Council.
That is 2016, my lord.
Have you gazetted that? Why are these called guidelines? These are not rules, is it?
No, my lord. These are guidelines.
And these guidelines will come into force when they are gazetted.
They have themselves said. That is their counter. They have annexed the document.
You see,
and my lord, even
this court, you see, this court has been shown by Mr. Amitav Das, learned counsel appearing for the Bar Council of Orissa State Bar Council.
State Bar.
A copy of a letter dated 22nd August 2022 of the Bar Council of India, inter alia informing it that, you see, you already took that long order, the RERA matter. Then what's the point of the same person taking all the long orders? Just ask somebody to come. Copy of the letter dated 22nd August 2022 to the Bar Council of India, which inter alia states that the list of non-practicing advocates received from the Orissa State Bar Council, open quotation, is hereby approved, unquote, subject to a condition which, according to Mr. Das, has already been complied with. He further states that on the very next date, that is 23rd August 2022, the list of non-practicing advocate has been circulated to all the bar associations of Odisha, apart from the registry of the Supreme Court and the High Courts.
As well as the Supreme Court.
Yeah.
In 20.4.
Paragraph. Mr. Ashok Mohanty, learned senior counsel appearing for he further states that a revised time frame for holding state elections to the State Bar Council will be filed along with an affidavit of the Secretary of the Bar Council of Odisha before the next date. Mr. Ashok Mohanty inter alia points out that the 2016 guidelines, mandatory guidelines for conduct of elections to the bar councils of the states, is supposed to be operative from the date on which it is gazetted. To the best of his, he says that to the best of the knowledge of, to the best of his knowledge, they have not yet been gazetted. Mr. Das states that he will seek specific instructions in this regard and indicate in the affidavit to be filed what steps have been taken to have the 2016 guidelines gazetted. It is made clear that if it is not already gazetted, it should be gazetted forthwith. List on 28 September.
Lord, can it be earlier? Otherwise, again, they will take time for publication and.
No. Already, it is made clear that the adjournment granted today is not meant to be taken as a postponement of the schedule that has to be complied with by the Bar Council of Odisha.
Yes.
For holding elections. All right.
Supplementary item 65.
65, my lord. My lord, the petitioner, my lord, is a central cooperative bank. My lord, it is agreed with the order of the Honorable Singular, my lord, at Annexure 1, my lord. Annexure 1 series, my lord, page 12. Whereby, my lord, the Honorable Single Judge, while nullifying the Annexure 3 and 4, my lord, whereby the ARCS, Aston District Cooperative Society, my lord, directed to stop locker, operation of locker. Therefore, my lord, the petitioner, the respondent, my lord, has filed the petition before the Honorable Court, and the Honorable Single Judge has allowed, my lord. Here, my lord, the fact is that I have lordship on the last occasion, lordship.
Also to pass an order of the nature contained in letter dated 24th July 2020. What is that? You see the previous order, 3rd August.
Yes, that 3rd August, my lord, order is that to supply, my lord, the relevant extract, my lord. They suppose the power of the assistant registrar to decide the dispute case and to pass an order of the nature contained in letter so and so. The letter, my lord, that relevance. So whether the assistant registrar has the power to direct for operation,
you say,
my lord?
No, this is an affidavit or?
No, my lord, they have not.
You say the council,
yes, not specifically.
In compliance with the order dated 3rd August 2022, the council of the appellant has placed on record relevant extracts of the relevant rules, relevant statutes and the rules, as well as the notification dated 18th August 1965 under the Orissa Cooperative Societies Act. You say notice.
May I please, Your Lordship?
You accept
I'm
for one.
appealing for the petitioner, rate petitioner.
Yeah, he accepts for respondent number 1. Who are the other respondents?
Other respondents are state, my lord.
All right, Mr. He accepts notice for 3, 4, and 5. Who's for 2? 2 is the Panapana.
Yes, well, that is a society which, my lord, affiliated to the Upland Bank, my lord. The Upland Bank used to grant financial assistance.
No. So they're relevant parties or not?
Yes, my lord. The relevant party, in fact, the
Notice
petitioner.
now to respondent number 2.
Yes. Here, my lord, we have appeared in the capacity of an intervener.
All right. Registered speed post returnable on the next date.
Lordship, since a huge public money is involved, Lordship, I pray, my lord, that be the order be state, my lord.
I am objecting, my lord. The bank appeared before the honorable single judge and disclosed they have no objection for operation of the locker.
No, my lord, that is not the fact.
I am submitting, my lord. Kindly have glanced to order dated 21st March 2022, my lord, passed by honorable single judge, my lord.
No, only one person is being permitted to operate the locker. What is this huge financial implication?
My lord, because a lordship, the respondent, my lord, when there is an order by this from the single judge to open the locker, it was found that amount 3 crore of gold is there, my lord. 3 crore of gold, my lord. And my lord, her husband, who was in charge secretary of Panapana Cooperative Society, my lord, against him there is that he has siphoned off the money which was collected, my lord. We have raised a dispute case that is also pending before the registrar.
Oh, I see.
My friend submitted such a statement. If the 3 crore value of gold articles are there, file a bond or file an affidavit to that extent. Inventory has been made as per direction of the honorable single judge. And as per the inventory, small gold ornament of female like nose ring and rings, no necklace even found in the locker.
No, 1 minute. The order dated 20th April 2022 says that the aggregate value is between 50 and 70 lakhs.
But that was submission without assessment also. Before the honorable single judge.
So let's order an assessment. I think that's the best. Okay, what we can do is let the locker be opened by you in their presence and let a valuer value what is the value of whatever is there in the locker.
My lord, inventory list has prepared. Your lordship direct for valuation of that amount.
So she should not be permitted to operate it. Yes. You open it in her presence. You have a valuer present there. And let whatever is in the locker be removed and be valued. And then kept back in the locker.
Well, initially, the order has been passed. I am class to the impugned order before the honorable single. Before the honorable single, in the order, air says.
No. Depending on the value of the articles in the locker, we'll then think of consequential orders for her to indemnify you. If they want to remove, then they have to indemnify.
Yes,
so let's first assess the value.
That will be in the presence of assistant registrar, my lord. Assistant registrar, my lord, the competent authority. Lordship, I pray that in his presence, such inventory may be made, my lord.
Inventory and also valuation.
Inventory already.
Lordship is good.
You say, as far as the interim order is concerned, the order of the impugned order of the single judge shall remain stayed, but subject to the following further directions. 1, the locker shall be opened by the assistant registrar of the cooperative society. Cooperative bank, right?
Cooperative society, Baleswar Circle, assistant registrar, cooperative society, Baleswar Circle.
Assistant registrar, cooperative societies, Baleshwar Circle.
OP number 4.
Bracket OP number respondent number 4.
Yes, madam. Sorry.
Bracket on. We fix a date also. or you fix the date later?
Now, date may be fixed. So
Lordship may be fixed.
On 3rd September?
Lordship, little bit, Lordship, because time is so small.
No, when can it be a weekday then? On 9th September.
9th September.
On 9th September at 11 a.m. in the presence of the respondent. 2, an inventory will be taken of all the articles in the locker. 3, an accredited valuer will be asked to remain present and undertake the exercise of valuation of the articles in the locker in the presence of the parties in the room of the branch manager or whatever. No?
Yes.
In a room to be provided for that purpose by the branch manager of the appellant bank. 4, after the inventory is made, the list be signed by all the parties, with copies being given to each of them of the said list. The original of the list will be placed on record before this court along with an affidavit of the appellant. You see, after the exercise is complete on that date itself, the articles will be kept back in the locker, which will again be kept under lock and key. Paragraph, the above exercise is without prejudice to the rights and conditions of the parties and is subject to further orders of the court. All right.
Well, inventory with the valuation, your lordship directed to submit the inventory list with the valuation also.
With the valuation, yes. All right. With the report of valuation. Right.
So respondent 4 will be directed. Respondent 4.
Yes. The affidavit, those documents you place with an affidavit.
Lordship.
All right.
My lord,
next date will be 12th October.
So
A read appeal memo may be served. Since I have appeared, read appeal memo may be served. Appeal memo.
I will serve.
Item 66.
Lordship, that if not maybe stayed, my lord. That's subject.
Item 66.
They're pursuing the content. That is the difficulty, my lord.
Yes.
Item 66.
Item 66. I am supposed to file counter affidavit. The director has instructed me to take 3 days time. Next Wednesday, your lordship may fix for final hearing. By Monday, I will file counter affidavit. Next Wednesday. This is relating to constitution of a managing committee of 2 colleges. So it is important we have already prepared the counter. By tomorrow, Monday, we'll file it, and Wednesday, your lordship will fix.
Madam, copy में पहले भी serve.
Mr. D.
I will serve. Immediately, I will serve it.
Well, the learned AGA seeks and is granted 2 more weeks' time to file a affidavit, counter affidavit, along with all the relevant documents. Rejoinder there to be filed before the next date. List on 28th September.
Supplementary list item 67.
Item 67, my lord, in the second connected writ petition, that's 32208 of 2021. Mr. Pitambar Acharya has instruction to appear in the matter, but he's on accommodation. The concern of the opposite party has already been taken in this regard. May this item be taken up 2 weeks after, my lord, so that in the meantime, we'll also file the rejoinder.
All right. Rejoinder filed for the next
Interim
date.
order to continue.
List along with writ petition civil. You said there's one more petition.
Yes, lordship, I think on 28th July, this writ petition was heard and it was directed to be tagged along.
Which writ petition, sir?
That's 13992 of 2022.
That's already there in the list today.
So no, lordship. I think I will file the rejoinder in the meantime and interim order to continue in 32208 of 2021, my lord.
I see. All right. Interim order to continue in 32208 of 2021. List on 16 November.
Obliged, my lord.
Supplementary list passed or matter. Item number 2. Please, madam. The challenge was made. The order passed by the single judge
in which, my lord, the award has been modified to the extent of instead of reinstatement, that is.
How is this writ appeal maintainable, sir?
My lord, in the self-same ground, another junior workman was.
How is the writ appeal maintainable? This writ petition is exercised under 227, correct? It's under the award of a labor court.
Well,
so the writ appeal is not maintainable against that, sir. Against 227, there's no writ appeal.
My lord, it has been, my lord, the only ground is that.
Not on the ground, sir. Kindly follow the question.
My lord.
You filed this writ appeal against an order of a single judge.
My lord.
That order of the single judge is in a writ petition challenging a labor court award.
My lord.
Is that order in a writ petition under 226 or 227?
That is under, my lord, 226 and 227.
Sir, against that, there is no writ appeal maintainable.
My lord, he is continuing, my lord, and his case has been recommended for regularization. Case has been recommended for regularization to the government, my lord.
Then in that case, you don't want to pursue the writ appeal, then you withdraw the writ appeal. His case is being considered.
Continuing by virtue of interim order. Continuing by virtue of interim order passed in the writ appeal.
But the writ appeal itself is not maintainable.
My lord, is continuing the changed circumstances.
Where is the
interim order dated?
Who's for the other side?
My lord, my senior.
So you have no problem with the writ appeal being entertained?
Pardon? That is under 227, the award was passed. Award was subject to your lordship's jurisdiction under Article 227. Your lordship rightly pointed out. At that time, writ appeal and stay order was passed. That was
Lord, they have
expected order.
You had no problem with it, sir. You let the stay order continue for 9 years. You've never objected to the maintainability of the writ appeal. We are only asking him this question.
That is a point of law, my lordship rightly pointed out.
I don't think you were even crossed your mind. Today, if I had not asked him this question, you would have not even raised the objection.
I would have raised because
No. I don't think there's no attempt to have an application for vacation of the stay.
2015 Supreme Court decision.
All that is fine. Since 2013, the stay is continuing. You've not filed an application for vacation of the stay. You should have first of all pointed out to whichever the division bench that is not even maintainable.
DLR employee. He's a DLR employee. No approval, nothing, and they are continuing. In a writ petition, PIN direction was given by this Honorable Court to make an inquiry also. So many irregular appointment that was given, engagement was given in the CMC, and that has been allowed now. That has been stopped. And one of the matters is the award. That was also only ended with the compensation that has been carried to the Supreme Court by the employees. And in that, it was not interfered. That order I have kept. I would have shown to your lordship.
Annexure 11 and 12.
So all that's happened is the single judge has enhanced the compensation to 80,000.
Well, instead of reinstatement.
Correct.
Well, in the similar circumstances, in the same award, same ground, same day retrenchment, Annexure 11, the municipality challenged that management challenge, page 48.
And a similar order subsequently Supreme Court has passed the order.
And this person, this award passed was confirmed, and they have filed the management filed writ appeal also, page 56. In the writ appeal, it was confirmed. The learned single judge order was confirmed. That is reinstatement. They have gone for the SLP. And after lust in SLP, they have reinstated that workman, the junior workman, Annexure 13, page 72. I bring all this notice to the single judge. In paragraph 3, page 76 of the impugn order. Learned counsel appearing for the opposite party workman submitted that the tribunal has taken into consideration the acquittance roll filed by the opposite party number 1 for the month of so-and-so, and since in the written statement, the management nowhere has stated that the workman are not working under the management since so-and-so, to the date of discontinuance. The next page, my lord. In support of his contention, he had cited the
unreported decision of the division bench in writ appeal number so-and-so, where the disposal upon so-and-so by the chief executive officer the so-and-so, Atul Kumar Barik, who is a junior to me. It appears from that the similar placed workman who was disengaged in 2001-6-2002, that is the same day, filed an appeal before the labor court. The labor court passed an award of reinstatement with 20% of bank wages towards compensation. The petitioner corporation filed writ petition challenging the award of the labor court, taking similar plea regarding so-and-so, so-and-so. The learned single judge confirmed the award of the labor court. The division bench of this court, taking into consideration the decision of the apex court in the delay electricity supply undertaking and Basanti Devi and another reported in so-and-so, while upholding the award, enhanced back wages to 25,000 to 50%. And this order also challenged in SLP, and the SLP was also dismissed, filed by the management, and they have reinstated the junior person. And I have relied upon your lordship's recent decision in my flag C I have given today, in which your lordship has decided that once in paragraph 9, that once a junior person has been retained, my lord, that I have page mark it in, my lord, 17. Paragraph 17, page 22. The lordship sort of. The above decision do support the case of the workman here. The fact that the workmen were engaged for more than 240 continuous days and worked for more than 5 to 7 years and continuous way, which management was unable to dispute factually. In fact, the management witness one support the case of the workman to that extent. The further fact of the person junior to the workman had been retained while the workman had been retrenched was unable to be disputed by the management. My lord, in this case, my lord, the person against whom, my lord, the award was, the retrenchment order was passed, and it was confirmed by the single judge, and they have filed writ appeal. That was also confirmed, and they have approached the Honorable Apex Court. The SLP was dismissed. They have reinstated that junior person in page 72, annexure 30.
What do you say, sir? But your lordship, kindly see, recently I have given that judgment, that order of the Apex Court. Similar employees and the division of bench of this honorable court passed the award, only compensation. They had carried the appeal to the Supreme Court. The honorable Supreme Court did not interfere.
No, enhance the compensation.
Only enhance the compensation. Because, my lord, how we can retain so many employees DLR, which is dehearse the law, they have been given engagement without sanction post, without approval of the government. Or that was the case. Exactly the same.
Which is the 7/12/2018 order of this court? Which is this? The 7/12/2018 order. Which is this?
7/12/2018.
The Supreme Court order which you have handed over.
Yes,
is against an order dated 7th December 2018.
Yes, yes.
Where is that order? Which is that order?
That order I can give because 9 o'clock we got the list and there is no time to make any research or to find out. We are facing difficulties, because every 9 o'clock lists are coming. All junior people, junior councils are also saying, why you are not ventilating to the Honorable Chief Justice? Where unless the ready list come, it is very difficult to find out all the files 9 o'clock. And we are every day we are going to the bed at 12 o'clock. Now our life span is reducing. That's if consider. Because earlier what was happening, the daily weekly list was coming, only few matters were coming for the admission. So that it was being possible to get ready. Even supposing we want to get instruction from any office is closed in the 9 o'clock. We can't get the development. That is where facing difficulties.
Okay.
Now, my lord, they have
so
recommended
a ready list if it comes, so that we can be aware that matters will be coming.
No. The ready list is for final hearing matters.
Final hearing. Otherwise, if weekly list
kind of matter, sir.
Weekly list are there, only few matters, admission matters come, press admission.
No, but this is in the weekly old. This is old matter, but this is already.
List is coming at 9 o'clock, 10 o'clock. Yes. So we are facing difficulties.
2020, they have recommended.
I could have got everything, that judgment, everything is there.
All right.
I could have obtained from the CMC office. Exactly the same case.
They have recommended for regularization. My serial number is 59 in 2020.
Your Lordship knows that the Umadevi case, by virtue of the stay order, somebody continues, that period cannot be taken into consideration.
All right. At the request of Mr. Mohanty and Senior Counsel appearing with the CMC, you just give it back to him. This to him. List on 18th October, interim order to continue. All right.
Pastor matter item number 50.
Item number 68, my lord. Item number 68.
No, 50. I think what is called out is 50 now.
50, 50.
Mails.
None appears despite a password. List dismissed for non-password.
Supplementary list for hearing item 68.
Item 68, my lord, I have not received paper book. Tomorrow I will receive. Next week, your lordship fix, I will argue the matter.
Just give him the paper book right now, sir. Copy of the paper book has been handed over to counsel the appellant. You're in both appeals or only one?
In both the appeal, my lord. And in one case, senior advocate is appearing.
Paper book, we have also not collected.
List along with the regular matters, I think. Why should it jump the queue then? Yeah. Next week, all right. List next week. All right.
Supplementary list item number 69.
Item 69, my lord. On behalf of Mr. Juggala Kishore Bond, I pray for 2 weeks after, my lord.
List next week again. All right.
Supplementary list item 70.
My lord, item 70, I have not received the paper book.
All right.
There was an order passed by the Honorable
Just give him the paper book right now.
Yes. I had to file an affidavit because after granting the bail order, the petitioner could not be released on bail for more than a year. So the Honorable Division Bench was directed to file an affidavit. I will file the affidavit also.
All right. List next week. Call it. Mr. Katke is here that 1991 matters, sir.
Weekly list.
Quickly. I have prayed for to be taken up on Thursday.
Tomorrow.
All
right.
From weekly list.
Yeah, give him the paper book.
Weekly list.
That will never be. I think from next week we should start calling up. Now we'll leave it this week. Next week we'll start calling.